There are a lot of. There are lots of kind of a joint prayer. Item number 31, the matter has come up for hearing.
My lord, this matter may be taken up in the month of September.
September,
My lord.
on request of learned counsel for both sides, let this matter be listed in the month of September on a date to be fixed by registry.
Preferably 17th September.
Let the registry fix the date.
Your Lordship, the interim needs to be continued.
The interim order shall continue till next day.
Much.
Obliged, ma'am. May I please, your lordship?
Yes,
Lordship, I beg to mention item 32, lordship. In this matter, I am seeking for some accommodation for today, your lordship.
you have informed the other side.
I'm there, Your Lordship.
I am for respondent side, your lordship.
Heard Mr. What is your name?
PK Ballers.
Heard Mr. P.K. Bora, learned counsel for the respondent who seeks an adjournment for some personal difficulty.
If Manish Gupta is leading us in this matter, lordship.
Mr. D. Senapati,
I appear for the appellant.
learned counsel for the appellant, does not have any objection to the same. Hence, prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
It will fix, your lordship.
Your Lordship, they are from Delhi. I'm also, can it be on 27? It will be around 4 weeks then.
Date
26th, 27th of.
12th of November.
Oh, much.
Earlier cannot be held.
Earlier it will be difficult.
Obliged.
Much obliged.
May I please, your lordship? Lordship, with due consent from the other side, I beg to mention item number 28 of today's list. We have served an adjournment notice yesterday, lordship. May I pray? I appear for the appellant,
And Miss M. Datta,
A. Chakravarti, lordship.
A. Chakravarti, learned counsel for the appellant who seeks an adjournment. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment.
We are for the respondent.
What is her name?
Jay Bosha on behalf of.
Also had Miss J. Bosho appearing on behalf of Mrs. N.C. Das, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on the date to be fixed by registry.
Most obliged, lordship.
Wait, please, your lordship. Your lordship, in regards to item number 8, the contending counsel is out of station due to some unforeseen circumstances. Your lordship, I pray for an VC link as he would appear through VC link, your lordship.
There is a
Yes, your lordship.
protocol how to pray for VC.
Your lordship, he went this morning, your lordship, so we couldn't apply for the link.
You have to apply on email. You can apply now also.
Yes, if you.
You follow the rules.
Much honor.
Yeah, please, your lordship. With concern of the other side, my lord, I beg to mention item number 10, my.
Yes.
My lord, there is a settlement discussion going on, my lord.
What is your name?
Hemanto Gogoi, on behalf of S. Das.
Heard Mr. H. Gogoi appearing on behalf of Mr. S. Das, the learned counsel for the appellant. You have informed the other side, who prays for an adjournment on the ground that a talk of compromise is going on between the parties. And there is a possibility of reaching an amicable settlement. Hence, he prays for an adjournment. The prayer,
Kindly case may be placed before the local order, my 12/9, going to be held on 12/9/2026.
let this matter be listed before the next Lok Adalat. Yes.
Obliged.
Your lordship, I beg to mention for a MAC appeal number 309 of the 2022. It's a debt-based matter, your lordship, and the matter has not been listed since 4/3/2025.
Orders. 5th of August.
With the consent of the other side, I like to mention for the item number supplementary 43 and 44, supplementary list. In this case, Mr. P. Khatuniar, he's having viral fever and is unable to conduct the hearing today. 3 weeks time may be granted.
What is your name?
43 and 44.
What is your name?
N. Rahman.
Heard Miss N. Rahman, learned counsel for the respondent, who prays for an adjournment on the ground that conducting counsel for the respondent is indisposed. She submits that she has informed the
Yes.
learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
May it please your lordship, I beg to mention in regard to item number 26, lordship. I'm appearing on behalf of A. Acharya. And we have also informed the other side.
And Mr. S. Dutta, learned counsel, appearing on behalf of Mr. A. Acharya, the learned counsel for the appellant, who seeks an adjournment. He submits that he has informed learned counsel for the respondents regarding the prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Much.
May I please, your lordship? Lordship, I beg to mention for listing, for hearing. Lordship,
No mentioning for hearing. Hearing you have to pray before the registry. Pray before registry. Yes, next.
Lordship, the similar prayer, Lordship, one
Similar.
hearing matter MSc appeal on
Pray.
listed on leftover hearing matters, Lordship.
Pray before registry.
Lordship, on that was listed on 21.
Orders come. 5th of. Or you may pray before registry. You have 2 options.
Then
Yes.
Orders follow.
may it please your lordship, I beg to mention item number 30 for hearing. We have taken consent from the respondent.
Heard Miss D. Goswami, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Stop. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed.
Because hearing matter. Let me.
12th November.
So.
Lordship?
12th of November.
No, let me stop sir. Let me stop sir, no problem.
12th of November.
Lordship.
May I please, your lordship? Well, actually, I'm arrested on 26/3/2025, and more than 400 days I am behind the bar, lordship. Now, lordship, what has happened here? The evidence has always proceeded, and it is the evidence of the IO which is pending. But the problem is there, lordship, in the trial court below, there is no public prosecutor, lordship. And the proceeding has in fact come to a standstill. It was from May 18.
What is the offense?
It was offense is lordship, NDPS, lordship, commercial quantity bus. Lordship may kindly have a look into annexure number 2, page number 18. That is the notice under 47 BNSS, lordship. That is absolute,
Where is the court?
lordship.
Which court?
Special NDPS Kamrup Metro.
In Kamrup, we don't have any special public prosecutor.
Lordship, no. Because this has been newly, court has been newly designated. Presiding officer is there, but PP is yet to be appointed. It is the difficulty, lordship. Yesterday it was fixed, but we don't know the next date. The court is not functioning properly. They are giving dates only for production. No date for evidence has been given.
Yes.
However, out of the 8 lordship, 6 has already been over lordship.
No, I
No,
understand.
why PP is not appointed? What is the difference?
Otherwise, materials are there, lordship.
No, that part is all right. Material is there.
Suppose
6 witnesses
everything
has
is
been
there,
done.
you don't prosecute.
Lordship. It may be appointed in a short span of time.
No, nobody is able to say anything, Lordship. I have taken a, can I speak little bit? I have taken information yesterday, Lordship. They are unable to say when the PP is going to be appointed. Since 18/5/2026, there
Okay,
is no
we'll take it up at 2. I'll inquire from Registrar Vigilance
at 2, Lordship.
at 2.
Please.
Registrar Vigilance of the Korean Chamber.
No, in this case, my lord, the petitioners who are not named in the FIR lordship are in judicial custody, my lord, for 69 and 54 days respectively, lordship. Now, practice, my lord, there was a group fighting between, my lord, two parties, lordship. My lord, as regards land dispute, my lord, the land is a subject matter of a title suit, lordship. Dispute was, my lord.
What is the offense?
My lord, offense, my lord, one person from other side was, my lord, unfortunately died in the hospital, lordship. Now, kindly see, FIR is at page, lordship, page 17, lordship. Cross FIR is also there, lordship. In that case, charge sheet is submitted. Page 17, lordship. Annexure 1.
What is the name of the petitioner?
My lord, petitioner's name is not there, lordship. Kindly see the list of, my lord, accused, lordship, at page 18, lordship. My lord, total 14 accused persons, accused are, my lord, in the name in the FIR, lordship. One is, my lord, he is on absolute bail granted by this honorable court, interim bail, lordship, anticipatory bail, lordship. My lord, Shahali, accused number 2, he is on, my lord, interim bail, lordship granted interim bail, lordship. Taqdir Ali is on absolute bail, lordship. Shahjahan Ali, he is, my lord, he was arrested, my lord, he has been released as per the order of this honorable court, lordship. Muhammad Ali, he is on interim bail, lordship. My lord, Azizur Rahman, he was arrested, lordship. He has been granted bail by this honorable court, lordship. Shafiqul Islam, my lord, he is on interim. Rustam Ali, lordship, he is on interim, lordship. Now, Meser Ali is granted absolute bail, absolute bail by this honorable court, lordship. Ahidur Rahman on absolute bail, lordship. Zakir Hussain on absolute bail. Nazmul Haq, absolute bail, lordship. Tafadzul Haq on absolute bail.
Where is the order? Bail order.
My orders, lordship. Yes, lordship. Next, lordship. At page 46, my lord, all the orders have been, my lord, the next, lordship, but the interim bail order has, my lord, page 46, lordship. These the 46, my lord, this is accused number 4 and 6, lord. Shahjahan Ali, they were arrested, lordship. My lord, considering the length of detention, they were released on bail, lordship. Now, next is, my lord, accused number 3, Taqdir Ali, lordship. 48, lordship. My lord, this is, my lord, interim bail, lordship. Subsequently, his bail was, my lord, made absolute, lordship. My lord, that order is not, my lord, enforced as because this was filed earlier, lordship. Now, next is, lordship. This is accused number 1, Amez Ali, lordship, at page 51, lordship. This may be, lordship, page 51. Lordship, got it, lordship. My lord, relevant is, my lord, page 50. Amez Ali is accused number 1, lordship. Page 52, lordship. My lord, page 52. My lord,
Yes.
married.
Yes, Mr.
Yes,
Lal.
Lord. What I have seen, lordship, I am only talking about his role, lordship. As far as the CD is concerned, I have seen that, lordship. These all the persons have went to the trespass the land of the 15 persons, lordship, and they uprooted crops caused damage to the property, lordship. And during that period, Lordship, they have killed one person, Lordship. And the person is Zamir Ali. The person died, and his death in the opinion caused why he died, Lordship. The cause of the death, Lordship, it is opined as coma as a result of head injury, Lordship. And the witnesses have named him, Lordship. Put the petitioner's name.
No, not named Lordship.
In the witness, Lordship, not in the FIR.
Yes.
Nothing of the FIR. The witnesses have named.
Apart from him, any other accused have been named, or only these two accused?
Many
They are
other
also
persons.
named, but they are on bail.
Okay, that may.
All
Other
14, my lord.
names are there, Lordship.
All 14 are of male, Lord.
Any other person's names are
And
also.
Mr. M.H. Ahmed, learned counsel for the appellant, learned counsel for the petitioner, also Mr. K.K. Das, learned counsel for the learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Mokhtarul Islam alias Mukhtar Hussain and Jahangir Alam, who are detained behind the bars since 25/2026 and 4/6/2026 respectively, in connection with Dolgaon PS case number 41/2026 under section 103 within bracket 1/118 within bracket 2/190/191 within bracket 2/324 within bracket 4/329 within bracket 3 of BNS. The gist of accusation in this case is that on which date affair was lodged? On 7/3/2026, one Mofizuddin had lodged an affair before the officer in charge of Dolgaon police station, naming therein 14 numbers of accused persons, inter alia alleging that on 5/3/2026 at about 12:30 a.m., the accused persons named in the FIR, armed with deadly weapons, trespassed into the lands of the first informant and uprooted plantations from the field. And they also beat the father, brother, wife, and nephew of the informant, causing injuries on their person. The father of the first informant succumbed to his injuries in the hospital. The learned counsel for the petitioner submits that the petitioner number 1 has been detained behind the bars for how many days?
69 days and 54 days.
69 days. Who is
My lord, accused number, petitioner number 1 is 69 days.
69
And
days?
2 is 54
And the
days.
petitioner number 2 has been detained behind the bars for 54 days. He submits that none of the 2 petitioners were named in the FIR, whereas in the meanwhile, most of the FIR named accused persons have already been granted bail, or either absolute or interim. As such, he submits that considering the long period of detention and Also considering the fact the co-accused persons are already on bail, the present petitioners may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Dalgaon PS case number 47/20. No, Dalgaon PS case number
41.
Oh.
41.
41/2026 and has submitted that there are incriminating materials against the present petitioner and other accused persons in the case diary, as independent witnesses have named them in participating in the alleged offense. Stop. It appears that there is a cross case pending against the informant side, which has been registered as Dalgaon PS case number 47/2026. It also appears that in the meanwhile, most of the named co-accused in the affair have either been granted anticipatory bail or absolute bail by coordinate benches of this court. It also appears from the case diary that investigation in this case has substantially progressed, though same is yet to be completed. Stop. Considering the fact that co-accused persons are already granted bail, as well as considering the fact of period of detention as well as progress made in investigation, this court is of considered opinion that further, if both the petitioners cooperate in the investigation, their continued detention may not be necessary for fair completion of the investigation of this case. As such, they are allowed to go on bail of rupees 50,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamruk Metro.
My lord, this is Mongol Doilos.
Learned Chief Judicial Magistrate Dorong,
Mongol.
Mongoldoy, with following conditions. Condition number 1 and 2. This bail application is accordingly disposed of. Send back the case diary.
Much of the
Order.
May I plead the lawsuit? My lord, this appeal is against the impugned judgment order dated 11/3/2015, passed in way number 24645 of 2005. My lord,
Just a minute.
this is the under section 74.
Vigilance of Kudibon. NDPS court
Hmm.
PP appointments in illness.
No, no.
If act Kudibon.
October. पूजा किती
Yes, court of PP appointments.
पूजा कोण किती
Yes, sir.
आपसर पूजा
Yes, Ms. Chakravarti. Yes,
So my lord, this case has been fixed for hearing, my lord. TCR has been received.
we'll fix it for hearing.
Yes, my lord.
Heard Ms. U. Chakravarti, learned Senior Railway Council, appearing for the appellant, also Mr.
A Dev.
A. Dev, learned counsel, appearing for respondent. Let this matter be listed for hearing on 12th of November.
Much obliged.
12 no. Yes, my lord, it is a matter of the grade concession of 25%, 6%. So under or against the impugned judgment order date 17/8/2016. So this also may be fixed for hearing, my lord.
Same order.
Your lordship, but different date if possible.
Yeah, 10th November.
Much of.
Then no.
The lordship, I'm so responding in this case.
Where is the appellant?
CR received. But the only question you are hearing is whether the appeal before the honorable court disposing order 39 rule 1 and 2 application equality limits. That the order passed by the municipal courts, civil judge unit division, your lordship can be in injunction application can be appealed before the honorable Gauhati High Court. Before this honorable court.
The impugned order is of Munsif Court. Then appeal lies before Civil Judge Senior Division.
Civil judge. In fact, your lordships, this is the case which I have filed is under 6 of a special relief act. So under that act, your lordships, appeal doesn't rise in the final degree, against final degree. Revision lies before this honorable court, your lordship. So this is regarding the final decision of the case and the degree. Now the question is here, you understand, it is a proceeding under order 39 injunction application.
You have not raised this question.
Your lordships,
Okay,
I have already filed a affidavit.
okay. None has appeared for the appellant on call. Mr. N.N. Jha, the learned counsel for the respondent, sole respondent
So let's-
is present, who raises the question of maintainability of this appeal. He submits that appeal in this case ought to have been filed before the Court of London, Civil Judge, Senior Division. However, since none has appeared for the appellant, let this matter be listed. No. First week of August, 7th of August.
May it please the lordship. My lord, will peruse the order dated, my lord, in this case, 24/6/2026 for a moment, my lord.
I number 1988.
Yes, my lord, but it was passed in all the matters, my lord, in the 6, 7, in the MFA 27, 28, and in the IA, my lord.
It
This
is
was a
for
common order
hearing.
been passed in that,
Hearing.
for hearing it was fixed, my lord.
Here already come. So Mali fixed on as earliest date. Entire case will be heard. Because it was in a hearing list, this was. But in the meantime, it's 5 months.
Second week of August.
20th of August.
11th August.
11th, my lord. 11th.
11th August, or it will go to November.
I'm there, sir, depending on my seniors.
20th,
No,
18th.
Not on 18th, my lord.
10th,
Any other date apart from 18th, my lord, I'm there.
13th August.
16th of
This appeal is ready for hearing.
Hello.
These appeals are ready for hearing, hence list these appeals for hearing on 13th of August,
Under hearing column, my lord.
under hearing column.
That's it.
Deep level, my lord. Sir.
This is also my lord claim for the graded concession of 25%, 6%.
These are ready for hearing.
Yes,
My lord.
Ready for hearing.
Yes, my lord.
yes, your lord.
But
It's fixed for hearing, my lord.
it's you, Chakravarti, learned counsel for the appellant, learned senior railway counsel appearing for the appellant, and Mr.
A, they.
A. Dev appearing for Respondent, these appeals are ready for hearing. Accordingly, list the same for hearing on 10th of November.
Lordship, a different date if possible, because others are also doing other matters.
Spelling date there. 17 November. 17 November.
Right, Your
17 November.
36.
My lord. All are 17. My lord, 3 cases on 17 November.
They are tagged together.
Yes.
Similar case.
Obliged, Your Lordship.
May I please be with you? Because this case was settled with the New India Express Company at 380, then local the claimant could not come. So they had to take instructions from the.
Your
Yes,
lordship,
Your
actually today we'll receive the instruction, whether the award has been settled on our part of.
Whether say,
Yes, lordship.
is it
Did-
settled or not?
Date Lordship. Next date may kindly be given Lordship, and no problem. You take a.
We'll fix it before Lok Adalat, 12 November.
No, Lordship, next 19/8 Lordship.
12 September Lok Adalat is there.
No, this was fixed in the Lokadar Lordship, and Lokadar it was settled, but the claimant was absent. So it was put on the regular.
No, what is your submission now?
Your lordship, today we'll receive the instruction from the officer. of
You
the-
will receive, you have
Yes.
not yet received.
Oh, your lordship.
Okay, okay. Heard Mr. A.R. Agarwal, Learned Counsel for the appellant. Also heard Mr. S. Datta, Learned Counsel for the insurance, who submits that they will receive the instruction as to whether matter has been settled in Lok Adalat or not today only. Hence, prays for some time to make submission after getting the necessary instructions. Prayer is allowed. Let this matter be listed.
10/8 is we given.
10-8.
10/8 Lord.
Okay.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of the respondent.
My
My
lord,
lord,
Pattern matter, already last occasions, my submission has been recorded, my lord.
Kanyasi.
The response is directed to,
No. It is only for submission of written gist of argument.
yes, my lord.
yes, my lords. My lords, I'll supply my written submission. My colleague is there. He'll hand it over along with the judgments, Your Lordship.
You will also be submitting any written gist.
But I am not submitting, already I have submitted already, my lord.
Okay.
But Lordship asked me to submit and then I submit my written. Yes, my lord. But is it, last occasion, Lordship said that this is not required, already my submission has been recorded. Only the respondent is directed to file the written gist.
Okay. Heard Miss U. Chakravarti, the learned senior standing counsel railways, assisted by Mr. G. Goswami, the learned counsel appearing for the appellant. Also heard Mr. D. Rathi, the learned counsel for the respondents, who submits that he has submitted written gist of his argument as was directed by this court on 21/7/2026. Stop. Hearing concluded, judgment reserved.
Obliged, your lordship.
Grateful, my lords.
What I was submitting is that when I've shown the judgment, if your lordship finds that it is, the will is in suspicious circumstances, then and if it hurts your lordship's conscience, then the we will, my lord, in question may not be acceptable. I have shown judgment, I will read 1 or 2 paragraph out of there. Your lordship, I have taken your lordship through PW2. And now I think I'll have to go through the PW3. PW 1 and 2 have gone. PW 1 is the beneficiary. He stated, may I take your lordship quickly so that that's page 59, my lord.
59 of the memo of appeal.
Yes. That is PW 1.
Yes.
Earlier, I have shown your lordship the judgments passed by various courts, which says, my lord, your lordship, for the purpose of probating a will, one has to see whether he was in good condition, where he is written, whether any suspicious circumstances. So PW 1, he says, my lord, the land belongs to 3 brothers. One died, so and there is a title suit which has been decreed in favor of the present appellant, but he is continuing to possess the land. And he doesn't accept where his the will was executed by his brother. May I take your lordship to page 59 once again shortly, man? May I read, man?
Yes.
I state there our father, late Mohini Nath Hukon, Hukon had 3 sons, including me, the opposite party, Devendra, Nath Hukon, and the deceased testator of the will. On the death of the father, I, along with my aforesaid 2 brothers, inherited 1 bigha, 1 kata, 17 lechas of land at Ulubari, that is at Barwari, my lord, Assam, along with a Assam type house standing thereon. The aforesaid land and houses are not yet partitioned, and presently the same is exclusively in my occupation. He says it is in his occupation. My lord, I state that the deceased testator of the will, Nipendranath Phukon, was residing at Jorhat, and he was a bachelor. My said elder brother Nipendranath Phukon died on 2009. That I said that my said brother, deceased brother, testator of the will, was the exclusive owner and the title holder of land measuring 1 bigha, 3 bigha, 3 kathas, 14 lachas of land, pata number so and so at Jorhat, and the house standing thereon. Besides the said landed property, my deceased brother, Nipendranath Phukon, had also 7 numbers of shares under the Bahini Tea Company. That I state that I, being the younger brother of my said brother and testator of will, Nipendranath Phukon, loved me as I always kept good relationship, maintained and look after him till his death. On the other hand, the opposite party, who is residing at Ireland, at no point of time had kept any contact with his deceased brother, and even did not attend the Sardha ceremony held at Bahini Tea Estate, and all formalities, duties, last rituals as per Hindu rites was done by me. Rather, during the lifetime of the testator, the opposite party, claiming his right, title and interest over the land and house situated at Gauhati, situation so and so, instituted a title suit number so and so against me and my said deceased brother Nipendranath Phukon, the testator of the present will. Because of this reason, my said deceased brother Nipendranath.
This was a partition suit.
Mala?
This was a partition suit.
Yeah. Now there is a title suit also.
No,
Title
what suit? Partition suit.
Partition suit is also there. Your lordship will come. Suit has been decreed. He is not leaving the position. Even 1/3 of the property, admittedly,
This title suit number 24.
Yes.
Is it a partition suit?
Yes, your lordship is correct.
Okay.
Against me, but he has not left the position of the house. Your lordship will say, just note his mindset. Testator of the present will. Because of this reason, my said deceased brother Nipendranath Phukon had no good relations with the opposite party. I state that after the last ritual being over, as there was none to look after the house of my deceased brother, this escape, your lordship, I was allowed to bring all his files, papers and documents, and accordingly the same were brought by me to Gauhati. That I state that after the death of my brother testator of the will, the present opposite party initiated a partition case number so and so before the landed circle officer, Gauhati Revenue Circle, in respect of the landed property in Gauhati. Accordingly, I was asked by the landed circle officer to file objection, if any, in that case. at the time of preparing the objection, particularly in the month of June 2011, while I was searching for the documents relating to the land of Gauhati, I traced out a copy of will dated so and so in the said files. How he is making the story itself is suspicious. In the said files of my deceased brother Nipendranath Phukon, which was executed by my said deceased brother, the testator of the will, in respect of his undivided 1/3 share of the property and house at Gauhati, the entire land and house at Jorhat, and shares of Bahini Tea Estate in favor of me as executor of the will. That I state that having found the said will or testament of my deceased brother, I, in my objections, have clearly stated about the said will executed by my deceased brother, Nipendranath Phukon, in my favor. I further state that on being asked to the writer of the said will, as well as to the witnesses, the said fact regarding execution of the will of the deceased, Nipendranath Phukon, was confronted by the said writer, namely confirmed by the said writer, Rajendra Kumar Sharma, and the witnesses, Minal and Siddhartha Datta. I state that the said will is the last will of my deceased brother. So exhibit is the copy of the last will, signature so and so. This is the thing. In cross, he says, my lord, land, page 63, the land described in the will is our ancestral property and we are 3 brothers. Now 6, your lordship will kindly see. There are 8 rented shops in our Gauhati property. We 3 brothers equally divide the rent amongst us. This is incorrect because the DW1 has already said that we are not getting any benefit of the houses. It is not a fact that I have falsely stated that the rent was divided equally. My brother Nipendranath Phukon resides at Jorhat, and he died at Jorhat at the age of 68 years. He was suffering from epilepsy. So he himself says, this is very important, himself says that that means he was suffering from epilepsy and he came to my place at Gauhati for his treatment. So it would have been the duty of the court to see whether he was in good health by examining doctors, by anybody, my lord, not on the basis of this statement. My said brother died unmarried to his share property divided in between me and elder brother. Now, next page, my lord. Before his death, my second brother was admitted in a nursing home at Jorhat, and now I cannot remember the name of the hospital where he was admitted. So it would have been the duty of the, my lord, Mr. Nipendranath Phukon to adduce the evidence of a doctor for the purpose of showing that he was at good health when the will was executed. I do not know if my elder brother sent any money for treatment of my second brother in the hands of Surendranath Phukon. I did not financially help my second brother during his medical treatment. He was looked after by domestic help while he was staying at Jorhat. I was present at the time of death of my second brother. It is not a fact that my second brother was having any disease of memory. My second elder brother came to my house in the month of July 2009. Then he was missing thereafter. This is important. This always raises suspicion. I searched for him and found him in a hotel at Polton Bazar. Before his death, he was admitted to a hospital for his treatment of epilepsy. I do not know about who wrote the will. In his house, the will was written. I do not know Rajendranath Kumar Sharma. I think it should be Rajendra Kumar Sharma. In the month of June 2009, I brought my brother to Gauhati for his treatment, and he was admitted to GMCH Gauhati, and he had gone to Jorhat in the last part of July same year. My brother Nipendranath Phukon intended to give his share of the property, executed a power of attorney in favor of me. I have not filed a state power of attorney in my case. I have not stated about the will in my case also. I have not filed the death certificate of my brother before the court. It is not a fact that after the death of my brother, I have submitted a letter to the management of the Bahini Tea Estate, which was written by my elder brother Devendranath Phukon, whereby he intended to gift out a part of his share of land to me. My brother Nipendranath did not inform me about the execution of a will before his death. A partition suit was filed for distribution of property amongst our brothers. I did not mention about the will in the said partition suit. The attesting two witnesses of the will also did not inform me about the execution of the will and their resident in Gauhati. Can anyone believe it, my lord? Your lordship will find from the subsequent, my lord, witnesses, they said it was signed in their house, my lord. My brother Nipendranath Phukon is a permanent resident of Jorhat. I know the writer of the will, Devendra Kumar Sharma. So if you know the writer of the will, then the writer will not inform him. I do not know his residence. It is not a fact that my brother Nipendranath Phukon did not make any will. It is not a fact that the will was subsequently prepared on a blank signed paper. Both attesting witnesses are friend of my son. He says the attesting witnesses are friend of his son and he knows Rajendra Kumar Sharma. I do not know where the will was executed by my brother. I do not know how seriously my brother was ill at the time of making the will. I do not know whether I will get more land from my brother Dependranath Phukon on the strength of the will. It is not the fact that the will was prepared by me after taking signature of two witnesses. Therefore, the signature of two witnesses were taken above the thumb impression of my brother. Now, PW2, your lordship, can you see is short. Minal Das. I am one of the attesting witnesses to the said will, that I state that I was present at the time of execution of the will and testament by said Nipendranath Phukon and saw the said testator affixed his signature thereto, that the said testator acknowledged the said writing in his will, last will and testament. That I state that the said Nipendranath Phukon, the testator at the time of execution of the will, was in sound state of mind. So he, on the basis of this, my lord, court comes to a finding that he was in sound health. He signed the said will in presence of me and two other attesting witnesses. Sri Rajendra Kumar Sharma, he is the writer of the will, and Siddhartha Datta, out of his free will and volition, without being influenced by any coercion and inducement from any quarter. Now, the lordship will kindly see his cross. I know Nipendranath Phukon and now he is no more. I signed the will in the house of Nipendranath Phukon at Gauhati. So house of the Nipendranath Phukon at Gauhati means same, Virendranath Phukon. Same house. They have the same house. So in his house only the will was signed. Nipendranath Phukon was a resident of Jorhat. Nipendranath Phukon, while coming from Jorhat to Gauhati, resides in the said house. His house at Gauhati means along with the brother house of the brother. Virendranath Phukon.
Where is that this house is house of the brother?
Malad, they have three houses.
No. Why you could not bring it from his mouth during cross-examination? That
But
this house.
he says that malad, I signed in the will in the house of Nipendranath Phukon at Gauhati. So Nipendranath Phukon only had one house.
No, where is that? Where is that evidence?
Well, admittedly, malad,
Where is that admission?
Admission is not there, but he says it is at his house. We'll have to understand. My God, we cannot go into that details.
No, this could have been brought from the mouth of the witness.
Let us see where it goes.
Yes.
Nipendranath Phukon was a resident of Jorhat. Nipendranath Phukon, while coming from Jorhat to Gauhati, resides in the said house. It is not a fact that I knew that Virendranath Phukon was the owner of that house. I know Nipendranath Phukon about 2 years prior to the execution of the said will. I met him while repairing a house behind the said house at Gauhati. I was called by Nipendranath Phukon over telephone to sign on the will. At the time of execution of the will by Nipendranath Phukon, two other persons were also present at the house of Nipendranath Phukon. I do not know them, and their name is also not known to me. but he's in chief, he has named them. In chief, he has given the names of two persons. The two persons mentioned in the third paragraph above was not known to me at the time of execution of the will, and I do not know their names. But in chief, he has given the names. By the will, Sri Nipendranath Phukon has given his share of property of Gauhati, his share of property at Jorhat, and his share of the tea estate. I do not know any persons. I signed the will as I was informed. At the time of preparation of evidence on affidavit, I was informed by one unknown person, and accordingly I came and signed the affidavit. I signed Exhibit 1 after signing by Nipendranath Phukon. It is not a fact that Exhibit 1 was a blank paper and having not thumb impression. The only thumb impression Nipendranath Phukon. PW3, my lord. Paragraph 3. And he said paragraph 2, my lord. I had that page 84. I state that I was present at the time of execution of the will and testament by the said Nipendranath Phukon, and saw the said testator affixed his signature thereto, that the said testator acknowledged the said writing in his last will. Exhibit 1 is the signature of testator Nipendranath Phukon. That I state that in Nipendranath Phukon, the testator at the time of execution of the will was in sound state of mind, and he signed the said will in presence of me and other two attesting witnesses, namely Rajendra Kumar Sharma and Minal Das, out of his free will and volition, without being influenced by any coercions and so and so. Put my signature on the said will as so and so. Then his cross is at page 86. I am a businessman by profession. My business relates to telecom and my place of business is at Gauhati. I know Birendranath Phukon and Nipendranath Phukon, as I was a tenant under them in the year 2007 and 8. So your lordship can find out, my lord, where it was signed. He was a tenant under them. Both Birendranath, Nipendranath, and Devendranath, they appellant. They are the brothers. They have their house in that Baruari house. This is common house belonging to three of them. And now he says, I know Birendranath Phukon and Nipendranath Phukon as I was a tenant under them in the year 2007 and 8. Now, Nipendranath Phukon in his witness as PW1, he says, I do not know anybody. This all raises a suspicious circumstances under which the will was made. Nipendranath Phukon was a resident of Jorhat, and I used to meet him when he used to come to Gauhati. That is their house, madam. I used to meet him in the house of Birendranath Phukon. So your lordship will kindly see. He says that I used to meet him in the house of Birendranath Phukon.
PW3 was the tenant.
Yes.
And Biren Phukon says that he does not know him.
Yes. And he says, my lord, came to me, I used to meet him in the house of Birendranath Phukon. That shows that means that house belongs to Nipendranath Phukon also. I do not know about his ailment. I am a witness in the will. And as such, I have been called today to depose as witness in this case. Nipendranath Phukon executed the will at his Gauhati residence. Obviously, my lord, Gauhati residence means along with his brother, where he comes and resides it along with his brother.
No.
I have never informed Birendranath Phukon about this will. Can anybody believe me? Both are known to Nipendranath Phukon, but he will, after signing of the will, he will not inform. Prior to the execution of the will, Rajendra Kumar Sharma, Minal Das was known to me. So all are known. When I went to the Gauhati residence of Birendranath Phukon, two more persons were already present, but they are known to him. One of them was writing the will.
So it was written in the house of Birendranath Phukon.
Yes. One of them was writing the will. Nipendranath signed the will. These are all Mili Bhagat, my lord. Nipendranath signed the will. First, then we signed as witnesses. It is not a fact that in between the last line of the
will and signature of the testator, I sign it as witness. Though I was staying at the house of Virendranath Phukon as a tenant, I did not have much contact with his son. But after 2012, his son came to my house and asked me regarding the will. It is not a fact that Nipendranath Phukon thumb impression was obtained in a blank paper and subsequently the contents of the will was scribed. And as there was a gap between the signature and the contents of the will, or put our signature as witness to fill up the gap. It is not a fact that the Virendranath Phukon and his son has manufactured the will that. Now, once again, my lord, I'll take your lordship to just have a glimpse of that will, my lord, page 50. Just see, my lord, thing else. Ultimately, my lord, 51. My lord, the schedule of the property is written, and this is how it is written. Maybe his signature may be correct, my lord. I'm not saying that, but this is how it is signed. Now PW4, my lord. That is at page 87. He is the writer of the will. That cross line, yeah. There is no cross. 87. I drafted the last will and testament of the testator, Phukon, as directed by Sri Nipendranath Phukon. I was also present at the time of execution of the last will, testament by the said Nipendranath Phukon, and saw the said testator affixed his signature thereto, that the said testator acknowledged the said writing in his last will and testament. Exhibit 1 is the signature of the testator. I state that said Nipendranath Phukon, the testator at the time of execution of the will, was in sound state of mind, and he signed the will in presence of me and other two attesting witnesses, namely Sri Minal Das and Siddhartha Datta, out of his free will and volition, without being influenced by any coercion. These are all pattern, my lord, of writing it. Now, my lordship will kindly see this DW1, page 90.
He was not cross-examined.
No cross-examination. The record doesn't show. But even then, my lord, writing of the will, whether even, my lord, even written objection is not filed.
In the trial court records also.
I think we might check.
Have you gone through trial court records?
No. I will check again.
PW4.
We'll check again. But it doesn't make any difference in a sense, because even if it is not cross-examined, it is the lordship's conscious. It has to be, your lordship has to be satisfied. Because I have shown judgment even in the absence of cross-examination, in the absence of written statement. If the court is satisfied, then there is no problem. But whether there is suspicious circumstances is there, or whether it can be believed that the will has been signed in this manner, so, in the house of the opposite party. I read, my lord, this DW1, page 90. Page 90.
Yes.
90. Paragraph 4, my lord. My lord, your lordship, paragraph 2, my lord, I affirm that the will in question is a manufactured one. The petitioner.
No, whether PW4 was cross-examined or not. What is your answer?
He is going to check. He has not been checked. Cross-examination.
Do you know or not? There.
Well, she checked it, but it is not there.
Yeah. What is there in the order sheets?
So check it.
You check it.
Their lordship, where lordship, the present appellant admitted that, yes, it is the signature of the testator.
That is all right. Signature.
Whether PW4 was cross-examined.
Yes.
He was cross-examined.
Well, I'll look. Morning, she looked into it.
I was not in the trial.
Oh. Okay. You, Mr. Das, you continue. You continue.
Yes. Page 90, my lord. that I affirm that the will in question is a very relaxed ordership, is a manufactured one. The petitioner, in collusion with the witnesses and writer, prepared the will for illegal gain, and as such, the probate application is liable to be dismissed. That the petitioner took signature of the testator in blank papers under the duress and coercion, and after his death, manufactured the will wrongfully to gain illegal. That I would like to emphasize that the testator was ordinarily residing at Jorat and was suffering from different ailment and used to come to Gauhati for treatment and reside in the ancestral house, which is under occupation of the petitioner. That the petitioner and his son were eyeing on the property of the testator and forcefully took his signature on blank papers, and after his death, converted the said papers into the will, and as such, the probate application is liable to be dismissed. Now, Lordship will kindly note that this property, the opposite party is in occupation of it. Despite my lord admitting that he is entitled to get 1/3 of the property, and despite the judgment in title suit, my lord, he has not given up the property. So your lordship will have to understand the will, at what background, my lord, this will has been signed. That the will so produced by the petitioner is not the will of our deceased brother, Nipendranath Phukon. That is so-called will itself does not inspire confidence to be genuine, as the thumb impression and signature of the testator is behind the signature of the so-called witnesses. My lord, if the will would have been there, my lord, there would have been very nicely, it would have been written with proper space and all. Why all this squeezing and the signature is down below? It shows, my lord, suspicious circumstances under which the will has been. And besides this, the fact that he is in occupation of the property. So somehow, my lord, he doesn't want to give the property. Even now, he has not given that 1/3 of the share of the property to the appellant. That the testator was not in sound and disposing state of mind and held before his death and was mentally incapable of thinking. Moreover, he was under forceful confinement of the petition. That the alleged signature of the testator is very shaky and doubtful, as it appears in the so-called will, and as such, the deposition made in the will are unnatural, improbable, and unfair in the light of the prevailing relevant. That the will suffers from undue influence, fraud, coercion, and as such, the probate application is liable to be dismissed. That the will is surrounded by suspicious circumstances, as the propounder took a prominent part in execution of the will, which confers substantial benefit on him, and as such, he is a beneficiary and also in possession of the property. And the same is liable to be dismissed with cause. That I beg to state that the petitioner is residing on their ancestral property at Gauhati, which the petitioner, I and our deceased brother, Nipendranath Phukon, jointly inherited from our ancestral property. That the petitioner, after the death of our father, has been enjoying the usufruct of this ancestral property at Gauhati and had not given the share thereof to me and my deceased brother, late Nipendranath Phukon, despite oral demands on various. So he is forceful occupation of the property. Owing to selfish way of enjoyment of properties, differences have arisen between us. Besides, the petitioner had constructed 8 shop rooms in the early part of 2005 without obtaining my consent, and has rented out the same to different people and has been enjoying usufruct thereof selfishly. So this is the mindset of the my lord opposite party. Whereupon I demanded from the petitioner on 2001 by notice in writing for partition of the said property, but the petitioner refused. The petitioner not only refused the property proposal of partition, but had also denied me my title. Under these circumstances, my title had become clouded, and as such, I filed title suit number so-and-so, praying for decree for declaration of my right title and interest to the extent of 1/3 share in the ancestral property. The learned Munshi, by judgment and order dated 1/8/2007, decreed the suit declaring my right title and interest to the extent of 1/3 share in the ancestral property. I would like to mention that here that the plaintiff has constructed possession over the suit property in the capacity of co-share. Despite this, my lord, he is not giving up possession. your lordship will kindly see what his mindset is. In the meantime, our brother Nipendranath Phukon died intestate, and I requested the petitioner to amicably partition the property. But as usual, he did not respond to my request. Under these circumstances, I filed partition case number so and so before the cycle officer Gauhati for partition of the land, and the same is pending. It is to be mentioned here that the petitioner appeared in the case and filed his objection and is contesting the same. That, sir, I beg to state that after the death of our brother, late Nipendranath Phukon, the land at Jorhat was duly mutated in joint name of the petitioner and me as his legal heir by order dated 2011, passed by the cycle officer Jorhat in so and so. That the petitioner never looked after late Nipendranath Phukon, who was residing in Jorhat and who used to visit Gauhati for treatment. While late Nipendranath Phukon was not keeping well for some time and had come to Gauhati for his treatment in November 2008. I had come to Gauhati for his treatment. I, in consultation with our deceased brother and our cousin, Justice so-and-so, decided to set up a trust to look after our brother Nipendranath Phukon. And accordingly, because this trust is, because he is unable to take himself or go around, he doesn't have the mental capacity to go around alone. I decided to set up a trust to look after our brother Nipendranath Phukon, and accordingly all the formalities were completed, but the petitioner and his son did not allow him to go out of the house and confined him in the house, and as such the trust could not be formed. That it is absolutely incorrect that the petitioner in the month of June 2011, while searching the documents relating to the land of Gauhati, he had traced out a will dated so and so in the said files of the disease, etc. I want to, a sick man signing a will in his house. He is a sick man. After all, this is the PW one also says, and this document also says, then it would have been the duty of the court to find out whether he was in very good health and what is the circumstance under which the will was made. And I want to state that the so-called will is an afterthought of the petitioner, and he manufactured the aforesaid and became the sole beneficiary. I would further like to state that the will is not the will of our deceased brother Nipendranath Phukon, and the petitioner in collusion with witnesses and writer manufactured the said will to gain illegal. That I would like to state that the so-called will is not at all the will of the Nipendranath Phukon. The same is manufactured one in collusion with witnesses and writer, and as such the petitioner is not entitled to provision. I would like to mention that the petitioner was found guilty of foregoing by forging my signature when he forged my signature in the letter where I was shown to have agreed to transfer our father's share of Gauhati estate in the name of petitioner's wife, and the said letter should have been in the files of Gauhati estate. That the statement made in so and so, the exhibit A, copy of the judgment dated so and so, death certificate is there, partition application is there, then the exhibit D, order dated passed in Namjari case number. All these exhibits are there. That the property, the Namjari mutation has been mutated. Then the partition case is pending, and the title should result in a judgment. But the PW1 is the beneficiary of all these things. Now in cross, I know the contents of my evidence in affidavit. I have been a resident of Ireland since 1968. I keep visiting India almost every year, sometimes twice. I do not remember if I had visited India in the year 2012. Visited India. I do not remember signing any other documents apart from my evidence in affidavit. I do not remember filing any written objection in this case. My present age is 71 years. 71 years now. He must be 78 or so, no? 71 years. Now he is much more, madam. I do not remember. 2018 he was 71 years. Now must be, madam, so almost 80, madam. I do not remember the contents of our written objection that may have been filed in the suit. I do not even remember swearing any so-and-so, any affidavit supporting any written objection. In any evidence on affidavit, my age should have been shown as 76 years rather than 71 years. That means it's more than 81 years. It is not a fact that I never used to visit India everywhere. I do not dispute, this is what the judgment relied upon. I do not dispute that the signature be bearing in Exhibit 1 are signatures of Nipendranath Phukon. I do not dispute, this should have been I dispute. But after all these things, he did not write it, he did not check it probably along with his advocate. So I said, if this is the only ground for allowing the will, then I filed an application for re-examination that is pending before this court. I cannot say, but if your lordship looks into this statements along with the statements of the DW1 and his affidavit in evidence on affidavit, it is clear that he is not accepting the will in any form, my lord. I cannot say when the signatures were taken, who had taken that, and where they were taken in Exhibit 1. I have not seen the signatures being forcefully taken from Nipendranath Phukon in Exhibit 1. It is not a fact that the allegations that the signatures were taken forcefully are based on assumption. The exhibits filed along with my affidavit were not filed along with the written objection. I have also not taken any leave from the court to produce this document in the form of exhibits. It is not a fact that the exhibits filed along with my evidence are not admissible in evidence. I have not submitted any medical document in support of my contention that the Nipendra was mentally not sound. I have not specified in my evidence on affidavit that what was the exact mental disorder that Nipendranath Phukon was suffering from. I had instituted civil suit bearing number so-and-so against Nipendranath Phukon. In that suit, I did not seek any appointment of guardian on the ground of the mental unsoundness of Nipendranath Phukon. It is not a fact that since I had myself instituted a suit against Nipendranath Phukon without disclosing that he was mentally unsound, Nipendranath Phukon was actually never suffering from any mental disorder. Although I have stated in paragraph 7 that Nipendranath Phukon was kept under forceful confinement by the defendant, I did not lodge any FIR regarding the same. When I had visited India in November 2008, I had met Nipendranath Phukon. It is not a fact that since I had the occasions to meet Nipendranath Phukon, it is wrong to suggest that he was under the forceful contention. Pursuant to judgment in title suit number so-and-so, I was granted a separate patta, but I have not exhibited the same. I have therefore separated my share by obtaining a separate patta. It is not a fact that since I have separated my share from the Esmali patta, I have no right in the remaining land. I did not visit India at the time of my brother's death, funeral rites. I have seen the medical documents pertaining to my brother's ill health condition, but I could not understand the same. I have made no attempt to produce before this court any medical document of Nipendranath Phukon. It is not a fact that all allegations regarding the mental soundness of my brothers are based purely on assumption. It is not a fact that I did not play any role regarding the treatment of my brother. I have not heard from anywhere that the signature of Nipendranath Phukon were taken on blank paper for the purpose of manufacturing the will. I have also not seen the signatures being taken on blank paper. It is not a fact that since I did not see signatures being taken on blank paper or heard about such happening, all allegations in my evidence are baseless. I have litigations pending against my brother Virendranath Phukon. It is not a fact that since litigations are pending against my brother, I have out of vindictiveness made false and fabricated allegations against Virendranath Phukon. So this is PW1 and PW2, your lordship will get it at page 97. PW1, my lord, DW1 has said everything against the will that he was not in good health, he did not produce. And also stated, my lord, I have stated that in paragraph 7, Nintendo was kept under forceful confinement. I do not dispute that signature bearing exhibits 1 are signatures of Nipendranath Foucault. So he says, my lord, he doesn't dispute it. Although, my lord, he said, my lord, I do not know. But it has been written in this manner wrongly. But for that purpose, my lord, an application has been filed for re-examination. If this can be the sole ground for allowing the will. So, my lord, this PW1 also says, my lord, he was not in good health conditions. Even the PW1 also says, my lord, he was not in good health condition. It should have been the duty of the court to find out whether really he was in good condition. Besides the others, the circumstances, suspicious circumstances, why he had to write it in a quiz manner and also in his own house, and why PW1 is hiding that it was not signed in the house of PW1. That is the only ground they said, because I do not dispute, even if I do not dispute the signature of my brother, I do not accept the contents of the will. I do not accept the contents of the will. So therefore, my lord, just because my lord signature is not accepted, I accept the signature, it doesn't mean that the court will just give the allow the will, my lord, in favor of the PW1. Because the petitioner, the PW1 did not, DW1 did not, my lord, say that I accept the contents of the will. And rather he says, my lord, he doesn't accept anything. And it was manufactured one, in short. This is what he says. The manufactured will. All his evidence will show. Now PW2, my lord, DW2, Minal Das, PW2. DW2. DW page 97, my lord. He is the director that I knew Devendranath Foucault. I know Devendranath Foucault, Birendranath Foucault, and late Nipendranath Foucault. He is my lord Samirendra Nath Foucault, son of Justice S.N. Foucault, resident of so-and-so, Assam, do hereby solemnly affirm so. I know Devendranath Foucault, Birendranath Foucault, late Nipendranath Foucault since long, and I'm the director of Gauhati Tea Estate, and as such, I'm acquainted with the facts and circumstances. That I know the testator was ordinarily residing at Gauhati Tea Estate, Jorhat, and was suffering from various ailments and used to come to Gauhati for treatment and resides in the ancestral house, which is under occupations of the petitioner. So, my lord, what I would like to say before his lordship, my lord, the learned judge, my lord, believed in the statements of DW1 and PW2 and PW3 as regard his health condition. That his health condition, they have said it is all right, so it is all right. But what about DW1? He says his health condition was not good. DW2 also says not. So they naturally, my lord, question arises before the court whether he was in good condition, particularly taking into circumstances the will which was written in a squeezed manner. It looks on the face of it, it's a manufactured one. That I know the testator was originally residing in Gauhati Estate, was suffering from various ailments, and is paragraph 2, my lord, and used to come to Gauhati for treatment and resides in the ancestral house, which is under occupation of the petition. That I state that the testator was not in sound and disposing state of mind and health before his death, and was mentally incapable of thinking rationally, as evident to my eye. That he was the director of the tea estate. That I know that the petitioner is residing on their ancestral property at Gauhati, which the petitioner Devendranath Foucault and their deceased brother Nipendranath Foucault jointly inherited from their ancestral property. That I know that the petitioner, after the death of their father, has been enjoying the usufruct of the ancestral property at Gauhati and had not given the share thereof to Nipendranath and their deceased brother late Nipendranath Foucault, despite oral demands on various brothers. So he also says that PW1, the opposite party, he is the only beneficiary of the property. Owing to such selfish way of enjoyment of properties, differences have arisen between them. That, sir, I beg to state that after the death of their brother, late Nipendranath Phukon, the land at Jorat was duly mutated in the joint name of the petitioner and defendant as his legal heir by order dated so and so. That I know that Nipendranath Phukon, in consultation with his deceased brother, Nipendranath Phukon, had tried to form a trust to look after late Nipendranath Phukon and his properties. But because of internal conflict with the petitioner, then say could not be formed. The Lordship will kindly take the facts and circumstances under which the will was made, and the intention, what could have been the intention of the PW1. That I was informed that the petitioner was guilty of forging my cousin Devendranath Phukon's signature when petitioner forged his signature in a letter where Devendranath Phukon was shown to have agreed to transfer their shares of tea estate in the name of petitioner's wife. This letter under reference was shown to me by Sri Devendranath Phukon. Now, PW page 99 cross. I am the shareholder of director of Bahani Tea Estate. The petitioner of this case, Sri Birendranath Phukon, is also a shareholder of Bahani Tea Estate. About a year back, the petitioner had proposed to sell his shares in Bahani Tea Company. We had done a valuation of the share of the petitioner, but the petitioner had objected to such valuation, contending it to be undervalued. It is not a fact that owing to the dispute in valuation, I had offered not to depose in the instant case if the petitioner withdraws his objection. It is not a fact that I have come to depose today only because of the ongoing dispute with the petitioner about the valuation shares. Late Nipendranath Phukon also has shares in Balaoni Tea Estate Tea Company, and he was posted as resident director in the garden. He was he was in charge of the garden matters, and he used to oversee the workers of the garden. I did not specify the exact ailments which Nipendranath Phukon was suffering from, paragraph 2 and 3 of my examination in chief. I am not aware of the doctors with whom Nipendranath Phukon used to consult regarding his ailment. I have not filed any document to substantiate the assertion that Nipendranath Phukon was suffering from any ailment. It is not a fact that since Nipendranath Phukon was capable of working in the garden as a resident director, he cannot be said to be operation of unsound mind. I do not know anything about the will, which is the subject matter of the instant proceeding. I have also not stated my examination in chief anything regarding the preparation of the execution of the will. I am not aware of the opposite party, Devendranath Phukon, had instituted a suit against Nipendranath Phukon. Whatever has been stated in paragraph 8 of my examination in chief was told to me by Sri Devendranath Phukon. We did not lodge any FIR regarding alleged incident of forgery. I have not produced the letter with the alleged forged signature of Devendranath Phukon. Devendranath Phukon had requested me to depose in this case. I had signed my evidence on affidavit in the advocate chamber. My evidence on affidavit and the evidence on affidavit of DWP is exactly same. I do not know anything about the will, and as a matter of fact, I have not seen it till date. It is not a fact that the statement made in my evidence on affidavit is false, and I have come to depose because of dispute with the petitioner. Now, it is DW2, his cross-examination is there. And that from a record I have seen, my lord. Could be. BW3. BW2, A2 cross, this is cross, my lord. So this is 3. 3, my lord, page 101.
Yes. Where is the evidence in chief of?
Yes.
Land?
I am the managing director of Bahani Tea Company. I know the contents of my evidence on affidavit.
Where is the evidence?
Page 101.
This is the cross-examination. Where is the chief?
Also, oh, that is, in chief, it is there, I think, from the record. Well, I did not have it, so did not. Got to do this. Yeah. Well, before that, I would like to submit the recorded concept. Like my colleague. Now, here is it.
Whether PW4 has been cross.
Yes, withdrawn. May I read that? Both the parties are represented by their learned advocate. Today is found fixed for cross-examination of PW4. PW4 is absent. Seen petition number so-and-so filed by the learned lawyer for the plaintiff side, praying for withdrawal of the examination in chief of PW4 on the ground stated there in the petition. The other side has no objections on the prayer for the plaintiff. Hence, prayer is allowed. The examination chief also stands withdrawn.
Okay, order dated. Order dated.
Order dated 5/8/2017. Order A2 here, PW32, chief, chief, and from protocol.
DW3.
DW4, DW3 now. Kalyan Protocol.
Why it was withdrawn?
There is an application. Out of station. There is plaintiff not able. Could have taken time, but he is not good.
The writer was not available. No, keep it in record. Is it paginated?
Page 171. Page 171. Like 171. 171.
Yes, don't remove it from record.
Okay.
Okay.
5/8/11. No, 5/8/17.
1987, petition number 1987, 2017.
Okay.
So it will chief to the PWD, DW3.
এই রেকর্ড তো ট্যাগ কৰিব
DW3, it says, I'm the cousin of, we have written it in handwriting from here. I'm the cousin of both the parties, and accordingly, I'm acquainted with the facts.
No, you read, I am listening.
Well, facts. That I know that the testator, my cousin, was ordinarily residing at Bahaniti State, Jorhat, and also suffering from various ailments, and used to come to Gauhati for treatment. He says that he was suffering. He was suffering from various ailments. The testator was not in sound and disposing state of mind and health before his death, and was mentally incapable of making property.
Okay.
I know. Huh?
Okay. No, you read, I am taking notes.
Yes. He says that he was not mentally, he was suffering from various ailments. And not in sound mind. I know that the petitioner is residing at ancestral property at Gauhati, which the petitioner D.N. Fukon and Disease N.N. Fukon jointly inherited. I know that after the death of father, petitioner is enjoying the ancestral. He also says that petitioner is enjoying the ancestral property and he has not given the share to D.N. Fukon. Your Lordship will kindly take into consideration his behavior and his his mindset. After the death of N.N. Fukon, the land of Jorhat was mutated in the name of so and so. But now, in view of this will, he has taken everything in his favor. Now, I was informed that petitioner was guilty of forging signature of D.N. Fukon, and his signature was forged in a letter to show that D.N. Fukon has agreed to transfer his father's share of Gauhati estate in the name of petitioner's wife. So your lordship will kindly note that proceed. It will cross. So I am the manager. See, his cross is at page 101.
Yes.
Well, I read, my lord. I am the managing director of Gauhati Estate. I know the contents of my evidence on affidavit. A few days back, the opposite party had raised the dispute regarding the valuation of a share in Gauhati company, and he had contended that I had unilaterally undervalued his shares. There was a discord between Birendranath Fukon and myself over valuation of shares. It is not a fact that I had proposed to not to dispose of depose in this case if Birendranath Fukon accept the valuations of the shares. It is not a fact that because of my discord with the petitioners, I have out of vindictiveness come to depose in this case. Nipendranath Fukon during his lifetime used to handle the affairs of Gauhati tea estate. He used to receive lump sum salary from the company while holding the post of resident director. It is not a fact that Nipendranath Fukon cannot said to be a person of unsound mind. Although he is to function as resident director in the garden, I have not stated in my affidavit about the exact ailment Nipendranath Fukon. I do not know doctor whom Nipendranath Fukon was consulted. I have a few vouchers connected to Nipendranath Fukon treatment, but I have not produced the same. It is not a fact that despite being in possession of the vouchers, I have willfully withheld the same because the same would reveal that Nipendranath Fukon was not a man of unsound mind. I have not stated anything about the will or its execution in my evidence on affidavit. I think that my evidence regarding the will is not relevant and important. I do not know about the will executed by Nipendranath Fukon, and hence I thought my evidence is not important in this regard. The allegations of forgery made in paragraph 8 of my evidence affidavit is based on whatever was told by Devendranath Fukon. I did not lodge any FIR regarding the alleged forgery, and I am not aware of anyone that is regarding transfer of my share of anyone else lodged in in an FIR in that regard. I have also not produced the letter containing the alleged false signature. It is not a fact that I have come to depose only to favor the opposite party, although I know nothing about the will executed by late Nipendranath Fukon. So this is what the evidences, my lord, comes to, my lord. The evidence is very clear that the will is and if your lordship looks into the evidences of all the PWs and the DWs, along with the evidence, along with the statements of the witnesses, and that the will was signed in presence of the witnesses in the house of the Birendranath Fukon. It shows that the will and that the manner in which the will has been drawn and signed, my lord, it shows that the will has been manufactured. And it ought to have been the duty of the court to see that he was in good health and it was signed in a good atmosphere, in the proper circumstances. So if your lordship looks into the judgment, at page 22. I will not take much time, my lord. 22. Start from page 23.
Yes.
My lord, these are all facts, my lord. Paragraph 22, your lordship will can. Facts and case laws. It discusses the various case laws regarding suspicions, suspicious circumstances, and ultimately, my lord, comes to the suspicious circumstances. I'll take your lordship page, paragraph 21.
Yes.
On going through the evidence on record, it reveals that the DW1 is the opposite party of this case. DW1 during his cross-examination clearly stated that he does not dispute the signatures of deceased Nipendranath Phukon in Exhibit 1, as I pointed out, my lord. And he had not seen the signature being forcefully taken. How can one see that somebody has taken the signature of the forcefully and all? He stays in Ireland. So it was signed in 2009. And just because I said, maybe, my lord, I have stated, even if your lordship takes into consideration that I accepted the signatures of so-and-so, that doesn't mean that I accepted that the will is perfect and the contents is perfect. And he had not seen the signatures of be forcefully taken from late. How can this is something very wayward, man. So it appears that the thumb impressions or signatures, whatever may be the Exhibit 1, not disputed by the opposite party defendant. Is it correct, my lord? My whole affidavit and evidence on affidavit, my whole cross-examination, everything says, my lord, it is manufactured will. It is the circumstances, my lord, suspicious circumstances are there. And he is in forceful possession of the property. So therefore, he has manufactured a will to benefit himself. Moreover, on going through the Exhibit 1, it also reveals that there is signature as well as thumb impression of the testator. That is not the duty of the court. The court has to see why the signature is down below, why it is squeezed, only to put the schedules of the property. Maybe the signature he has obtained from the Nipendranath Phukon when he was there, he must have got it in a blank paper. Then thereafter put it in that blank paper all the points regarding the will. And in order to put all the schedules of the property, my lord, he has squeezed in. What was the necessity of squeezing the handwriting, my lord, for the purpose of making the will? And the will was made in his own house, Virendranath Phukon. So it gives us suspicious circumstances, and it shows that the will has been manufactured to get the benefit of the property, my lord, which he is supposed to divide in 2 shares. My lord, your lordship may. I think your lordship will write.
Oh, I'll take a short.
Will late Nipendranath Phukon was in sound state of mind. So you have ignored the evidence of others. You have just taken the evidence of PW2 and 3 and just ignored all the evidences which have been adduced in the case. From the evidence of DW2-3, it reveals that till the death of late Nipendranath Phukon, he was working as a resident director of Gauhati state. So from their evidence, it also reveals that he was in sound state of mind at a time of execution of the will. This is court's own, my lord, without any proper analysis of the evidence. Here the court has recorded this. Humbly submit, my lord, this recording is not correct, and the evidence will show contrary that that he was
Indian succession.
PW2 and 3 in their evidence clearly stated that at the time of execution of the will, testator late Nipendranath was in sound. It's a gospel truth. Mine. To disprove the evidence of PW2 and 3, the defendant side could not be able to produce any document to show that at the time of execution of the will, deceased Nipendranath Phukon was not in sound state of mind. So from the entire evidence on record, it reveals that as per provisions of Section 63 of the Indian Succession Act, the petitioner able to prove the executions and genuineness of the will executed by testator Nipendranath Phukon, and there is no any suspicious circumstances of the will of the execution of the will. He doesn't discuss anything regarding the squeezing of the sentences in the will and the gap between the signatures and the will. So accordingly, my lord, will was probated, and your lordship, I'll just take your lordship, which I have already taken your lordship through the. Quickly, my lord, I have already taken your lordship through the judgment. I'll take that Meena Pradhan judgments once again, paragraph 10. It's a manufactured will on the face of it, man. His intention is to grab the property, which he is in possession for a very long time.
Para 10.
Yes. Para 9. Sorry, para 10. Roman 9, my lord. Para 10, Roman 9.
Yes.
9. The test of judicial conscious. The first judicial consciousness will come. The test will be why this will is in this squeezed manner. Why the signature is down below. And why PW1 is not accepting that it was signed in his house. Why is that? And he is in possession of the property and he has not divided the property.
And one more why is there.
My lord, so many whys are there.
One more why is that when the will was executed in the month of March,
yes,
why till September he did not inform
yes, that is
the
absolutely.
beneficiary that I have bequeathed? That is
Absolutely.
not answered.
2009 and he recovers in the year 2011.
No, that is a different aspect. But from March to September, he executed this. They have to also answer. He executed will in the month of March.
Yes.
Till his death, he did not inform
anybody,
the petitioner, that he has bequeathed property in his name.
That is also there. So these things, my lord, leads to suspicious circumstances under which the petitioner is claiming that the will has been signed. And your lordship will take into consideration that the PW1 only he is a beneficiary of the will. So he did everything what is required to continue in possession of the property on the basis of the will, my lord, manufactured by him. Paragraph 9, 10, 9, Roman 9. The test of judicial conscience has been evolved for dealing with those cases where the execution of the will is surrounded by suspicious circumstances. It requires to consider factors such as awareness of the testator as to the content as well as the consequences, nature and effect of disposition in the will, sound, certain, and disposing state of mind. Only basis of PW1 and PW2, you cannot say that he was a sound state of mind. And the circumstances, my lord. At the time of the execution, testator executed the will while acting on his own free will. 10, my lord. However, second sentence, however, even in the absence of such allegations, it is the duty of the court, my lord. If there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanations. Next page, my lord. 11. Suspicious circumstances must be real, germane, and valid, and not merely the fantasy of the doubting mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of the case. Any circumstances raising suspicions legitimate in nature would qualify as a suspicious circumstance. For example, a shaky signature, a feeble mind, an unfair and unjust disposition of property, the propounder himself taking a leading part in the making of the will under which he receives a substantial benefit. Your lordship will kindly take note of this. His handwriting down below, his thumb impressions, squeezing of the sentences, he is a beneficiary. He is denying that the will has been signed in his house, which has been accepted by his own witnesses that it was signed in his own house. My lord, it leads to the only point that the will has been manufactured only for the purpose of getting the benefit of the property which he is holding for a very long time and not giving the benefit to any of his brothers. And on the basis of this will, my lord, he is taking the whole of his property, my lord, in his name. He is continuing, he is running a shops, he is not giving benefit of the same to any of his brothers. So therefore, my lord, I submit, my lord, on the basis of the document itself. My lord, I would like to point out one more case, that matter of the goods of late Sri Kushanlal. Flag B, I think. Flag B could be Allahabad High Court. I'll take only one sentence.
Which case?
Paragraph 12.
Which case?
That Allahabad High Court case was in the matter of the goods of late Sri Kushan Lal. Your lordship got it?
Yes.
Can you reflect with you?
Yes.
Your lordship got it?
Yes.
Paragraph 12, my lord.
Yes.
Yes. Paragraph 12, my lord, down below, my lord. Down about 8-9 sentences. The law relating to the manner and honors of proof and also the duty cast upon the court while dealing with a case based upon a will has been examined in considerable detail in several decisions of this court. So and so, a constitution bench of this court in Shashi Kumar Banerjee case succinctly indicated the focal position in law as follows. My lord, the mode of proving a will does not ordinarily differ from that of proving any other documents except as to the special circumstance requirement of attestations prescribed in the case of a will by Section 63 of the Indian Succession Act. The onus of proving the will is on the propounder, and in the absence of suspicious circumstances surrounding the execution of the will, proof of testimony capacity and the signature of the testator as required under law is sufficient to discharge the onus. Wherever, however, there are suspicious circumstances, the onus is on the propounder to explain them to the satisfaction of the court before the court accepts the will as a genuine. Where the caveator alleges undue influence, fraud, and coercion, the onus is on him to prove the same, even where there are no such pleas, but the circumstances give rise to doubts. It is for the propounder to satisfy the conscience of the court. The suspicious circumstances may be as to the genuineness of the signature of the testator, the condition of the testator's mind, the dispositions made in the will being unnatural, improbable, or unfair in the light of the relevant circumstance, or there might be other indications in the will to show that the testator's mind was not free. So on your indications are sufficient. Indications are sufficient. It shows that you have manufactured the will for the purpose of grabbing the property. His health condition was bad. There is no attempt. And paragraph 17, your lordship will kindly see. 17 below, my lord. The place and timing on which the will was written, the physical and mental capacity of the testator at the time of his execution, the relationship of so-and-so, the other witnesses with the testator, the reason for which the testator desired to execute the will to a distant relative and to exclude his wife and daughters have not been sufficiently explained. Why his brother was excluded? Even if your lordship takes into consideration that will is there, why his brother was excluded? There is absolutely nothing on record to show as to why the testator excluded his wife and daughters and gave his entire property to the plaintiff. In the last sentence, my lord, in the absence of any evidence to remove these suspicious circumstances surrounding the execution of the document and the physical and mental condition of the testator, the propounder has not satisfied the court's conscience. The document does not speak of the for the testator. Yes,
Okay.
The Kavita Kaur case, your lordship will kindly take note of paragraph 24. 2021 11 SCC 209. Same principle, madam. Twenty-four. May I read, madam? 24.1.
Yes.
Your lordship will skip next page. Your lordship will kindly see. After about third sentence. Under section 67, if a document is alleged to be signed by any person, the signature of the said person must be proved to be in his handwriting. And for providing such a handwriting under section 45 and 47 of the Act, the opinions of experts and persons acquainted with the handwriting of the persons concerned are made relevant. Section 68 deals with the proof of the executions of the document required by law to be attested. And it provides that such a document shall not be used as evidence until one attesting witness at least has been called for the purpose of proving this exhibition. These provisions prescribe the requirement and the nature of proof which must be satisfied by the court who relies on a document in a court of law. Similarly, section 59 and 63 of the Indian Succession Act are also relevant. Section 59 provides that every person of sound mind, not being a minor, may dispose of his property by will, and the three illustrations to these sections indicate that what is meant by the expression a person of sound mind in the context. Section 63 requires that the testator shall sign or affix his mark to the will, or it shall be signed by some other person in his presence and by his directions, and that the signature of mark shall be so made that it shall appear that it was intended thereby to give effect to the writing as a will. So if your lordship takes into account the will again, does it, my lord, inspires confidence in your lordships, my lord, that this testator has signed the will in proper mindset? Does this section as to whether the will is set up by the propounder is proved to be the last will of the testator has to be decided in the light of these provisions. Has the testator signed the will? Did he understand the nature and effect of the disposition in the will? Did he put his signature to the will, knowing what it contained? Stated broadly, it is the decision of these questions which determines the nature of the finding on the questions of the proof of will.
Okay.
Now, subparagraph 19, my lord, last sentence, my lord, of this page.
Yes.
Continuing 24, last sentence. The subparagraph 19 of the same decision. The propounder would be called upon to show by satisfactory evidence that the will was signed by the testator, that the testator at the relevant time was in a sound mind, sound and disposing state of mind, that he understood the nature and effect of the dispositions and put his signature to the document of his own free will. Next sentence, the alleged signatures of the testator may be very shaky and doubtful, and evidence in support of the propounder's case that the signature in question is the signatures of the testator may not remove the doubt created by the appearance of the signatures. So that now in the middle of the thing, in such a case, the court would naturally expect that all legitimate suspicions should be completely removed before the document is accepted as the last will of the presence of such suspicious circumstances naturally tends to make the initial owners very, very happy, and unless it is satisfactorily discharged, courts would be reluctant to treat the document as the last will of the testator. It is true that even if a caveat is filed alleging the exercise of undue influence, fraud, or coercion in respect of the executions of the will propounded, such pleas may have to be proved by the caveators. But even without such pleas, circumstances may raise a doubt as to whether the testator was acting of his own free will in execution of the will, and in such circumstances, it would be a part of the nature initial owners to remove any such doubts. So I will not go into other aspect of the matter. The judgment says about all these circumstances, and even without a plea, this court can look into it. What are the contents of the documents, whether he has signed it in free will. In this case, my lord, I say, my lord, the will was signed in his house. PW1 says, I do not know. And he is in possession of the property. And the will itself shows, my lord, it's a manufactured one for the purpose of grabbing the property and becoming the owner of the property, inherited by the appellant's father, by the appellant and his brother from his father, ancestor's property. So therefore, I submit, my lord, the judgment passed by the court below only on the ground that the PW, he has accepted that it is the signature of the dependent Fukon without understanding only on the admissions of the appellant that he has accepted the signature of the dependent Fukon only on that ground, and on the ground of evidence of PW1 and PW2 saying that his health condition is good, and completely disregarding the other requirement of law and the other evidences which says that he was not in good health, and plus he is in occupation of the ancestral property, despite the judgment passed by this in suit, he is not giving the position, continuing in position. It shows his intention is to grab the property by manufacturing. I submit, my lord, that your lordship will set aside the judgment.
Yes, Mr. Lord.
Lordship, the entire pleaded case of the appellant defendant is based on falsehood. And falsehood.
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 He has pointed out 3 or 4 suspicious circumstances on which you have to make your submission. The first paragraph of the will is written in a squeezed manner. The signature of the testator has been obtained below the signatures of the witnesses, which is normally not done. Normally, after recitation, signatures of testator is obtained, thereafter witnesses. That he has pointed out. Then for 6 months, the testator did not disclose that he has bequeathed his property. Then
Disclose, Lordship.
no, on that you have to make your
There
submission.
is no provision in the Indian Succession Act, Lordship, that once the testator execute a will.
No, I am pointing out the gist of his submission, and that though the will was executed in the residence of the present respondent, he
No, it was executed in the residence of Nirpendranath.
On that aspect, you have to
Testator.
make your submission.
It is, my first submission is this law. When the defendant, present appellant, public defendant, himself in his cross-examination has admitted that he does not dispute the signature of Nirpendranath over the will.
Yes.
And the attesting with two numbers of witnesses, whose names are mentioned in the will, lordship, as deposed in favor of the respondent petitioner, lordship. So that is the requirement, lordship. The submission led by forwarded my learned friend that his third impression is the bottom. Is there any rules or law, lordship, that where the signatures are to be put? A document must bear the signature of the party. Where it should be done, somebody signs sometime on the right side, lordship, somebody signs on the bottom, somebody signs on the top, lordship. There is no such rules or any laws, Your Honor. That submission does not have any force. I advance by my learned friend. And lordship, I would like to place before your lordship the cross-examination of the appellant defendant.
My lord, only 1 point, if your lordship allows me, 1 point, 1 second. Well,
Yes.
that PW4 he has withdrawn, then who has, my lord, there is no evidence to show
Okay.
who at that point, your lordship.
Okay.
Who has, my lord, instructed him to write? Testator has given instruction. Not
Okay.
just,
Lordship, will you please to come to page 90 of the memo opinion. Cross-examination of the present appellant, lordship, Devendranath Phukan. I see Devendranath Phukan is about so-and-so, son of like so-and-so. I am para one that I am the defendant in the instant suit, as such I am acquainted with the facts and circumstances of the case. Cross-examination, your lord, sorry, I am. Page 94.
Page 90.
9.
Yes.
I know the contents of my evidence on affidavit. I have been a resident of Ireland since the year 1968. I keep visiting India almost every year, sometime twice. I do not remember if I had visited India in the year 2012 when the will was executed, lordship. I do not remember signing any other document apart from my evidence in affidavit in the case. I do not remember filing any written objection in the case. My present age is about 71 years. I do not remember the contents of our written objection that they have been filed in the suit. I do not even remember swearing in any in the affidavit supporting the any written objection. In any evidence on affidavit, my age should have been shown as 76 years, rather than about 71. It is not a fact that I never used to visit India every year. I did not dispute that the signatures appearing, this is important, lordship. I do not dispute that the signatures appearing in Exhibit 1, that is will, Exhibit 1 is the will, lordship, are signatures of Nirpendranath Phukan. So the lordship, the appellant defendant himself in cross admitting that he is not disputing the signature of the testator of the will, Nirpendranath Phukan. So he had admitted. Exhibit 1 in signature of Nirpendranath Phukan. I cannot say when the signatures were taken who had taken that and where they were taken. But my learned friend has submitted that the exhibit 1 was executed or manufactured at the residence of Virendranath Phukan, that is the petitioner who filed the probate. See the cross here, funniest thing. Signature, I cannot say why the signatures were taken, who had taken that, and when they were taken in exhibit 1. I have not seen the signatures being forcefully taken from Nirpendranath Phukan. Your Lordship may please to consider the contradictory averments made by the appellant defendant. In the objection, Your Honor, filed by the present appellant Lordship, that the will is a fraud, it is a manufactured document. Nirpendranath Phukan never signed the will, and here the appellant admitted in cross that he does not dispute the signature of Nirpendranath Phukan over the will. I have not seen the signatures being forcefully taken. My learned friend has submitted the signature was taken fraudulently and forcibly, Your Lordship. From Nirpendranath, exhibit 1 is not a fact that the allegation that the signatures were taken forcefully are based on assumption. The exhibit find along with my affidavit were not filed along with the written objection. This is the point, Lordship, very important point. Because, Lordship, when the objection was filed, which was subsequently treated as a WS file by the present appellant defendant, Your Lordship, he had not filed any document along with the objection. When he filed his evidence on affidavit, Lordship, he filed some document. And while doing so, filing the affidavit in opposition, no leave was obtained from the trial court for allowing the appellant defendant to grant leave for filing the documents which were not filed before settlement of the issue. It is well settled law that before...
What documents?
Lord.
What documents? Which documents should not be released?
Document they have filed with the evidence on affidavit.
Which?
DW1. DW1.
Which specific document you have?
They had filed. Trial court record. Ase? Ki? Record. Trial court record.
No, your submission is that those documents should not be relied upon.
Yes, it cannot be.
Yes, which document?
The documents which were filed along with the evidence on affidavit. Before filing evidence on affidavit, no documents were filed.
I got
before
your
settlement
point,
of
but
this.
which documents you are referring to?
Yes, I.
Judgment in title suit and all. Title suit judgment.
Ulwana to me, DW evidence on affidavit. I am taking out of it. Apart from that, Lordship, while the present appellant defendant had filed 3 numbers of suits against Nirpendranath. At that time, he was not, he was in full sound mind. Nowhere there is whisper in the plaint or in the judgment which were passed in the suits which were filed by the present appellant defendant, Your Lordship, against Nirpendranath Phukan, that Nirpendranath Phukan was a man of the unsound mind. And he is not mentally fit, nothing else. Lordship, in the trial court record, page 62, Lordship, para 17, Your Lordship, be pleased to note that while the evidence on affidavit was filed by DW1, as page 62 of the trial court record, Lordship, the present appellant defendants had filed Exhibit A, copy of the judgment dated 21st/8/2000, passed in title suit number 307/06. Then Exhibit B is the death certificate of Nirpendra Phukan. Exhibit C is the partition application in partition case number so and so. Exhibit D, order dated 17/3/2004, passed in Namjari case number so and so. So these documents were not filed when before settlement of the issue, and no leave was taken from the court for allowing the present appellant defendant to file these documents along with
No, but you are not, are you disputing that the testator has not died?
testator.
Testator has not died. That you are not disputing. You are also not disputing that he has not filed a partition suit.
No,
The-
he has filed a partition suit. Lordship, the three brothers, Nipendranath Phukan, Devendranath Phukan, and Virendranath Phukan, they are all entitled to get 1/3 say. But Nipendra Phukan, who executed the will, he did not get it. So there was no issue. So as per inheritance, both the living brothers will inherit his share, Nipendranath Phukan's share. But due to will lordship, Virendranath Phukan got the share of Nipendranath Phukan, who executed the will lordship. So my humble submission is this, your lordship, the documents which were filed by the present appellant defendant lordship were not filed when the WS or objection was filed. And he has admitted in the further cross-examination that he has not filed along with the objection. So it is well settled, lordship, if the documents are not filed by the party before framing of issues, such a document cannot be accepted if without taking the leave of the trial court lordship. That is well settled.
Okay, assume we don't accept those documents.
Pardon me.
Assuming that we don't accept those documents, what would be the result?
Nothing.
Nothing will.
Nothing.
Because neither you are disputing death of testator, nor you are
My learned friend had submitted regarding those filing of cases by the present appellant lordship against Nipendranath Phukan.
Yes.
So that's why I have submitted. Lordship.
But you are not disputing that he filed a partition suit.
No, I am not.
You are not disputing.
And those are not the subject matter of.
Yes, those are not the subject matter of.
So that my humble submission is this, lordship, as my learned friend has relied upon the judgment, partition suit, title suit, a mutation case. That's why I am replying.
No, his submission, to my understanding, was that in spite of partition suit being decreed, you are still possessing over the plot of his share of land also, in addition. That was his submission. Yeah.
I'm possessing my share, being the 1/3 share of Virendranath Phukan and share of Nipendranath.
Okay.
The share of the present appellant is intact. And that those things are not on the pleading. Those things, what my learned friend has submitted, that the plaintiff petitioner has been in the possession of the share of the land of Devendranath Phukan. That is not the case here. Your lordship is to decide whether the will was genuine or not, whether attesting witnesses deposed in favor of the petitioner's plaintiff or not, and if there was any suspicious circumstance. Those things can only consider as per the Indian Succession Act. Further, I would like to proceed with the cross-examination of DW1. Page 94, lordship, page 94, bottom line 2, line 3, forcefully based on assumption. The exhibits filed along with my affidavit were not filed along with written objection. I have also not taken any leave from the court to produce this document in the form of exhibit. It is not a fact that the exhibit filed along with my evidence are not admissible in evidence. I have not submitted any medical document in support of my contention that Nipendranath Phukan was mentally not sound. I am posing for a memo. Lordship, my learned friend repeatedly submitted that Nipendranath Phukan was not a man of sound mind. He was not in a state of, his mind of affairs was such, he could not take any decision. So he was suffering from various as well. So burden lies upon whom? Burden lies upon the appellant oblique defendant lordship to prove that Nipendranath Phukan was not a man of the sound mind and health.
Yes, he has pointed out two things.
Pardon.
While emphasizing this, he pointed out that the petitioner in his cross-examination has said that he was suffering from epilepsy, number one. Number two, that when he came to Guwahati on one occasion, he was found missing, and later on he was found in a hotel. This he has.
Lordship, a person who is suffering, assuming that he was the problem of epilepsy. So burden lies upon the mere making a pleading and not to. The burden has to be discharged. In the objection filed by the present appellant lordship before the trial court, there is no whisper regarding any epilepsy.
No, epilepsy, you yourself said. You in your cross-examination admitted.
Dicky member lordship जो है किताबा मानो एक बार दो बार महा तेरी अलग senseless हो गई तार से जितना ही sense आया था he works normally. The DW witnesses have admitted in the case lordship that he was managing the affairs of the Gauhati state lordship Nipendranath Phukan.
I am just pointing out. I am not saying that I am accepting either his plea or your plea.
No, lordship, a person who is a he I think singer Jubinger. He was also having he was the suffering from grave epilepsy lordship, and he was discharging his all duties lordship, singing a stage program, everything lordship. A person suffering from epilepsy cannot be equated with the unsound mind person. After epilepsy happens once or twice in a year loss. Yeah, and he was the director of the tea garden. Bahini tea state is a very big tea state lordship in Jorhat district lordship. So epilepsy cannot be a bar, and it will give no benefit to the present appellate law. Let me complete the cross. Very interesting. Page 95 clause.
Yes.
What was the exact mental disorder that Nipendranath Phukan was suffering from? I had instituted civil suit, being TS number 307/2006 against Nipendranath Phukan. In that suit, I did not seek any appointment of the guardian on the ground of the mental unsoundness of Nipendranath Phukan. So, Lordship, the suits, the partition case, mutation case, Lordship, when filed against Nipendranath Phukan by the present appellant Lordship, there was no whisper regarding any epilepsy or unsoundness of the mind. Which is admitted by the appellant defendant, your Lordship, in this cross-examination. I had myself instituted a suit against Nipendranath Phukan without disclosing that he was mentally unsound. Nipendranath Phukan was actually never suffering from any mental disorder. What more is required? In the pleading of the appellant defendant, Your Honor, he is saying that he is a man of unsound mind. He was not in a sound mind or good health. And here in the cross, I stated that the Nipendranath Phukan was not suffering from any mental disorder. What more is required? I did not lodge any FIR against the same when I had visited India in November 2008. I had met Nipendranath Phukan. It is not a fact that since I had the occasion to meet Nipendranath Phukan, it is wrong to suggest that he was under any forceful confinement. Maulana Friend has submitted that he was kept in the forceful confinement of Virendranath Phukan, that is the beneficiary. The defendant appellant himself is showing that he was not kept in the confinement by Virendranath
No,
Phukan.
no.
So that's why.
These are suggestion. You are suggesting him and he is only denying your suggestion.
He has not denied.
It is not a fact that since I was,
It is not a fact that since I had the occasion to meet Devendranath Phukan, it is wrong to suggest that he was under any forceful confinement pursuant to the judgment rendering TS number itna itna. I was granted a separate patta, but I have not exhibited the same. I have therefore separated my share by obtaining a separate patta. It is not a fact that since I have separated my share from Ismaili patta, I have no right in the remaining land. I have no right remaining land. I do not visit India at the time of my brother Nipendranath Phukan. The elder brother expired, Lordship. The appellant defendant, Lordship, did not come from the Ireland even to take the complete the rituals, Lordship, or the Shraddha ceremony. Because they were not in good relations, Lordship. Nipendranath Phukan, due to filing of the cases, Lordship, by Devendranath Phukan against Nipendranath Phukan, Lordship, they were not in good terms. Funeral rights. I have seen the medical documents pertaining to my brother's health condition, but I could not understand this. I have made no attempt to produce before the court any medical document of Nirendranath Phukan. So, Lordship, the pleading of the appellant defendant is that the Nirendranath Phukan was suffering from mental disorder, epilepsy, or this and that. But burden lies upon him. Devendranath Phukan, Lordship, to prove all these things, Your Lordship, he is depositing that he had some documents in his possession, but the same has not been filed. See the burden of proof. I have made attempt to produce before the court any medical documents of Nipendranath Phukan. It is not a fact that all allegations regarding the mental unsoundness of my brother and based purely on assumption. It is not a fact that I do not play any role regarding the treatment of my brother. I have not heard from anywhere that that signature of Nipendranath Phukan were taken on blank paper for the purpose of manufacturing the will. I have also not seen the signatures being taken on blank paper. The Mailana defendant submitted that signature of Nipendranath Phukan was taken on blank paper. The defendant, that is the appellant, presented himself saying that he does not know if the signatures were taken on blank paper or not. It is not a fact that I did not see signatures being taken on blank paper or heard about such happening. All the allegations in my evidence are baseless. I have litigations pending against my brother Virendranath Phukan. It is not a fact that since litigation are pending against my brother, I have out of vindictiveness made false and fabrication allegations against Virendranath Phukan.
we'll continue at 2.
Item number 36 and 37. Maybe fixed on 13th of August. Both sides is good.
37 and 38 laws.
37, 38,
13th of August.
13th of August.
For hearing.
Okay.
Item 21 also.
21.
Again for the day. Item 21.
When?
Lordship, any date after 2 weeks?
After 2 weeks on a date to be fixed by this.
13th को इधर.
Compromised or not? Settled or not? Because on that day you said that You don't have any instruction, therefore we were compelled to.
I have no instructions.
But now, do you have the instructions? Because I remember she was present and she stated that it was because you denied that we were.
They have not received that copy of the petition, that is why. Now, now he has served the copy.
No, earlier I have started because Mr. Bhutto refused to accept.
Miss Haflonger, we are sorry that we were compelled to direct your personal appearance because the council denied having any information about the affairs of the company, that the matter was settled in the Lok Adalat. Okay, we'll pass orders accordingly.
I am giving the bank account details of the claimant, so it may be, Mr. may kindly be directed to deposit straight away in the office.
I'll pass orders in chambers. These are disposed of in terms of the settlement arrived at between the parties in the Lok Adalat.
Yes.
Okay.
Amount may kindly deposit directly in the bank account of the respondent claimant.
Okay.
And the account of the.
Duta, Putulai Duta Chamber of Commerce. Yes, Mr. Roy.
Now I'd like to place the objection filed by the defendant appellant to appeal before the trial court. Page 52, 52.
52 of
Memo appeal.
yes.
First, you got it.
Yes.
Para 5 law.
Yes.
That will in question is a manufactured one. The petitioner in collusion with the witnesses and writer prepared the will for illegal gain, and as such the private application is liable to be dismissed.
52. Yes.
Then page 53, Lordship, para 6. That the petitioner took signature of the testator in blank papers under duress and coercion, and after his death constituted the manufacture the will wrongly to gain illegally. Then Lordship may come to para 9, which is important. The so-called will itself does not inspire confidence to be genuine, as the thumb impression and signature of the testator is behind the signature of the so-called witnesses. The thumb impression is also not of the testator. This is important, Lords, because the challenge the thumb impression that it is not the thumb impression of the testator, Lordship. Then why, what prevented the appellant defendant, your Lordship, to file an application before the learned trial court to send the specimen signatures of the thumb impression and as well as for the FSL examination, Lordship? They did not do it. They did not discharge their duty. Whether a thumb impression is correct or it is managed or somebody impersonated, Lordship.
But the person has already died.
No, the thumb impression over the will is
With,
there.
with
Lordship.
which thumb impression it would have been compared?
Which could have been compared.
Compared with what?
Which can be compared, Lordship, along, suppose, Lordship, he has filed, Devendra Fukan has filed 3 numbers of suits. So they are against Nipendra Nath Fukan. Their signatures are
Signature he is not disputing.
Lordship.
He is not disputing the signature.
He is not disputing the signature, but what is the averment, Lordship? In part
He is
9, Lordship.
disputing the thumb impression.
Third impression is not the thumb impression of Nipendra Nath Fukan. So to verify your Lordship, it was essential to file an application by the present appellant defendant for sending the matter to the FSL. That this was not done. Then Lordship may come to page 55.
Yes.
This is regarding regarding partition suit. This is next in the middle portion. It is a description regarding partition suit. Then your Lordship may come to page 56, para 23, last para. That the statements made in paragraph 11 and 12 of the probate application are not correct and hereby denied. The answering opposite party begs to state that the so-called will is not as well as the will of Nirpendranath Phukar. So here signature also denied, but in the cross signature has been admitted. The same is a manufactured one made in collusion with the witnesses and writer. And as such, the petitioner is not entitled to probate of the will. It is not out of place to mention herein that the petitioner was found guilty of forging the signature. Lordship may be pleased to consider what type of inconsistent averments have been made by the appellant defendant. Earlier, he has stated that it was forged. Thumb impression is not of the thumb impression of Nirpendranath Phukar. Now, in this para, Your Honor, the averment has been changed. Same is a manufactured one made in collusion with the witnesses and writer, and as such, the petitioner is not entitled to probate of the said will. It is not out of the place to mention herein that the petitioner was found guilty of forging the signature. Here, allegation is that it is the respondent, Your Lordship, beneficiary who forged the signature of Narayan Phukar, Nirpendranath Phukar. Earlier averments in the same objection petition says that it is manufactured, but the thumb impression is not of the thumb impression of Nirpendranath Phukar. See the contradictory averments.
It is relating to something else, man.
I had not interfered when you were arguing. Okay, I did not whisper a single word. Then Lordship, forging signature of the answering opposite party. When he forged signature of the answering opposite party in a letter by which answering opposite party was shown to have agreed to transfer the father's share of Bathoni Tea Estate in the name of the petitioner, while the said letter should have been in the files of the Gauhati Tea Estate. Now you see the verification of the objection, which is totally inadmissible. Whatever averments have been made in the objection is not admissible in law. Verification. I, Devendranath Phukar, answering defendant, do hereby verify that the contents of the paragraph 1 to 26 of the written objection are true and correct to the best of my knowledge and belief, and the rest are humble submission. Lordship, on a perusal of the objection, Lordship, wherein the matter of title suit, matter of the partition suit, matter of the mutation record, averments are there in the present. And he has verified what? Para 1 to 26 are correct to the knowledge. Nothing regarding records, there is any whisper. The settled position of verification and the affidavit has much value, Your Honor, until and unless there is a proper verification, the averments made in the object plain or objection of WS will be inadmissible. And in support of my contention, I would like to place Miramot. What copy? This is a judgment by the Honorable Justice Amitabh Roy in a case which was conducted by me, Your Lordship, Mira Bora. This is regarding the verification of the affidavit, plaint, or the verification of the WS or objection, or verification of the any other petition laws.
Which para?
Lordship may be pleased to come to page 3, Lordship. Both sides, I think. Page 3, Lord. Para 7. Para 7, Lordship. On a combined reading of Order 6, Rule 14 and 15 make it ambiguously clear that not only the pleading in a suit or proceeding akin thereto has to be essentially signed by the party and its pleader, if any, the same has to indispensably verified by him or her advocate or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case following the amendment as mentioned herein above. And affidavit also has to be filed by him in support of his pleading. The question of an affidavit in support of the pleading in the verified petition thereof, in addition to the opinion of this court, only underscores the inflexible and the binding nature thereof, so as to furnish the factual foundation of a party's case before a court of law that he or she expresses to be taken cognizance of and to be permitted to be proved by adducing evidence oral documentary. The proceeding before the para 8, the proceeding before the court in so and so was once under the Assam Urbanization Control. In that case, the defendant in the inter alia took a plea that the plaint has not been signed and verified in accordance with the law and without correct particulars of the premises. The court noticed from the narration in the impugned judgment and order that the defendant in course of his deposition did not challenge the signatures of the plaintiff in the plaint as well as the Wakalatnama, and that in spite thereof he said forum aid in law in personally verifying the signature to the said document. It is in this context that the court, referring to section 99 of the CPC, observing that an omission in the matter of signing and verification of the plaint would amount to an inner defect or irregularity held to the same to be a mere defect in the procedure, not affecting the jurisdiction of the court. In coming in this conclusion, his lordship placed the reliance on the decision of the Punjab and Haryana High Court in Srimati Mukhtiar Kaur versus Ghulam Akhtar. In response, so many other cases have been cited. I am skipping that. Para 12. Para 12. Having regard to the unambiguous languages applied by the legislature in section 280 of the Act and read in conjunction with the Order 6 Rules 14 and 15 as amended by the CPC Amendment Act 99, with all humility, I express my disagreement with the view rendered in Kailash Singh versus Hiralal Dey, Supra, having regard to the state of the law as the date requirement of the verification of the pleading as obligated by above provisions is neither a purely procedure essential nor any deficiency thereof would amount to a curable irregularity in proceeding of the kind as envisaged thereby, where a statement of the fact would form the foundation of the case of a litigating party. It is imperative that the same ought to be verified strictly accordance with the right of the law relatable thereon. In absence of such verification, such a statement of fact cannot be taken a cognizance by any court of law as such, so that any volume of evidence in support thereof would be wholly irrelevant and insignificant, as it in view of the fundamental law of the pleading and proof established would not have any probative value, having regard to the eventfulness mentioned in para 99 of the court, which are clearly define the plea that an omission in the matter of signature and verification of pleading in a civil proceeding would amount to be mere a defect or irregularity there does not command for acceptance. It is noticeable that the legislature in providing such a relaxation had consciously limited the same to cases where such a eventuality do not affect the merit of the case or the jurisdiction of the court. If a statement of fact is not verified in accordance with the law, in the opinion of this court, where there is no factual foundation of the case of any part of the party in detail, and therefore this understandably would have a determinative bearing on the merit of the case. If a court of the law takes a note of a statement of fact not being verified and decided the lease, the decision would be vitiated by a fundamental error affecting the merits of the case, and therefore has to be construed to be strictly, clearly beyond the ambit of the section 99 of the code. A law of procedure though made of justice cannot be exalted to a status to be a subversive of the law inevitable as the means for justice. Justice has to be essentially administered in accordance with the law. In the above view of the matter, even para 30. In the above view of the matter, even assuming that as on the date of evidence of the petitioner as well as her witnesses is not on record, the same is a vis for the petition for probate and not one for the letter of administration. It is not the case of petitioner that they had urged before the learned trial court to treat the petition for probate to be one for application of letter of administration. The conscious choose to have the petition for probate amended by integrating deletion and substitution, though the amendments were allowed. She admittedly failed to verify the same as required under section 280 of the Act. The amended application cannot be construed to be a wholesome substitute of the petition for probate to exempt the compliance of the section 280. The evidence on record in the opinion of this court is therefore of no significance to tilt the balance in favor of the petitioner her omission as ever understand. On a totally of the consciousness, the court therefore find itself in agreement with the decision taken by the learned court below. The petition therefore is rejected. So ultimately the petition was rejected only on the ground that there was no proper verification of the plate or WHO. So the verification in the objection is stated that para 1 to 26 are to my knowledge and belief. But where the averments made in the objection are part of the records also, regarding which there is no verification. Your Lordship, in support of my contention, Lordship, there is another judgment also, because the once given, Lordship, that cannot be changed or reset. In that respect, Lordship, I would like to place our own High Court Division Bench judgment. This case was also conducted by me. Lordship, please to this is the division bench judgment of the Honorable Justice V.D. Gyani and HKT Singh. Lordship may come to para 7. Para 7.
Yes.
Para 7, Lordship. Affidavit without proper verification held to be inadmissible and are not to be acted upon. Realizing the inherent information in the affidavit, learned counsel for the appellant offered to file a fresh affidavit by way of amendment. If the oath can also be improved upon. These are glaring infirmities in the record. Annexure 13, as per the affidavit filed by the advocate, he notified on 26/3/9, whereas records show that he was notified on the change of the others are not so relevant. Last three lines, Lordship, of the same para. Last from the bottom line 4. It must not be forgotten that the administration of justice in a very large manner depends on oath, which is the foundation head of purity of judicial proceeding. We are not touching the merit of the case, and ultimately there was an appeal, Lordship. Appeal was also dismissed, Lords, for improper verification, Lords. Here in the objection, Your Honor, we'll find next page, Lordship, page 58. Same is the condition with the affidavit in support of the objection. Your Lordship, page 58, para 2, that the statements made in this affidavit though made accompanying written objection and in paragraph 1 to 26 are to minor. Nothing regarding the records. But there are so many amendments relating to the records in the objection filed by the appellant defendant. So, Lordship, as per there are two decisions of our High Court that if there is no proper verification of the plaint or pleading or the affidavit, Lordship, in that case, statement made in such petition will be inaccessible. One thing I'd like to place before the Lordship. The appellant petitioner has filed an application for the re-examination of DW. Lordship, will you please to
Where? Before this court or before?
Yes, before this court, which
Order.
cannot be filed here. Re-examination is taken under order 18 rule 17 of the CPC, which is to be filed before the trial court. If there was any wrong recording, Lordship, in the cross-examination of the DW1, Lordship, a petition would have been filed before the learned trial court under order 18 rule 17 of the CPC. Your Lordship, will please to pay the order 18 rule 17 of the CPC.
They have filed any interlocutory application?
Yeah.
Yes, sir.
Interlocutory application is Lordship 1428 of 24. And how the Lordship, the PTS was filed in 2012. And Amatkopi Lordship, be pleased to note that इसमें कहीं लिखा था कुछ Lordship, be pleased to peruse that defendant was cross-examined on 19th of January 2008. Lordship, the defendant was cross-examined on 19/1/2018, and the present IA petition was filed, Lordship, on 20th of May 2024, after 6 years, and that too before this for re-examination of the DW1, Lordship. And here also, see, the funniest thing is that the carelessness on the part of the appellant is this, your Lordship, that
that this petition I may not address it because this was filed as an abandoned question, my lord. That is in your.
You are not pressing.
Yeah, I'm not pressing. The abandoned question because, my lord, the judgment at paragraph 22 says that I have accepted the signature. But accepting signature doesn't mean that I have accepted the contents.
Not pressing this.
The documents,
Lordship, just one carelessness I'd like to point before the Lordship.
Carelessness on my part. I've written.
Here,
the name
Lordship,
of someone.
see, applicant is, Lordship, page 2. Applicant is Devendra Nath Fukan, that is the appellant.
That is a typographical mistake. I'm not
Appellant.
accepting.
And let me place. Why are you have patience?
No, Mr. Roy, he is not pressing this.
Placing, Lordship, just one I'd like to place. Lordship,
That's a typographical mistake. He's in the shoulder.
Lordship, only one para two. Para two, Lordship, that the applicant appellant respectfully state that the opposite party defendant has filed probate case number itna before the court of the learned single judge, Kamrup Metro Gauhati, under section 276 of this court, granting probate in respect of the will dated executed by deceased Devendranath.
But that's a
And
typographical.
testator executor was the Nirpendranath Phukar.
That,
Here it has been shown that it was executed by
that
Devendranath
is
Phukar.
typography.
Devendranath Phukar.
Well, I'll give you
We'll
a cup
give
of
the
tea
that
for
out
that.
to have been corrected, Lordship. It is that paras also, same thing, para three.
Okay, he's
four.
not pressing this app.
Okay. And because Lordship, it is well settled law that if there was any mistake in the recording of the evidence of the DW, what? Where he has admitted that signature bearing on the will is correct, genuine, Lordship. If there was a mistake, they ought to have filed an application immediately before the London trial court, Lordship. Because, Lordship, if there is a mistake is committed by any court, review petition or correction petition put to be filed before the same court, not before the higher court, Lordship. This is very well settled, Lordship. So nothing was done by the appellant, Your Lordship. Now, Your Lordship, may please to come to the judgment, Lords, passed by the trial. Page 22. It starts from page 3 at 23. Lordship, may please to produce the issues framed by the learned. Issue number 1 is, Lordship, page 27. Whether the deceased testator let Nirpendranath Phukan executed the last will dated so and so, where he was in a, whether he was in a state of the sound disposing mount having capacity to execute will. Number 2, whether the petitioner was appointed executor in the said last will dated, whether the petitioner is entitled to get any probate of the last will dated replace and to other work, Lordship. So, Lordship, there is no issues were framed as submitted by my learned friend regarding the suspicious position of the will or circumstances, Lordship, and whether the signature is for, whether it is manufactured. There were no issues, Lordship. And the learned trial court has clearly, while passing the judgment, has held that the will was genuine, it was the last will. One of the submission of my learned friend was this, Lordship, that why the matter was regarding the execution of will, the Virendra Phukan, that is the beneficiary, was not informed. Is there any provision in the Indian Succession Act that the executor of the will, he should inform the beneficiary? Because, Your Lordship, in case of a will, a testator, executor of the will can revoke the will at any time during his lifetime. That's why, Your Honor, there is no provision in the Indian Succession Act to inform the beneficiary that I have executed a will, because before my death, I can change my will at any time. I may revoke, I may appoint other beneficiary, Lordship. So that's why, and there is no provision in the Indian Succession Act, Lordship, to inform the beneficiary, Lordship. Right. Now, the and the will was signed at in the house of Nirpendranath Phukan at Gauhati, Lordship, and no, not in the house of Virendra Nath Phukan. Lordship, I'd like to finish. Before that, I would like to place on High Court. Lordship, there is a judgment of by this honorable court pronounced by Honorable Justice Devassis Borua. Facts of the present case and facts of that Honorable Justice Borua are same. Yeah, photo. Are same. In this case, your lordship, a private proceeding was filed, and the defendants, while appearing lordship, in the WS has admitted that yes, his mother has executed a will in favor of the daughter of the deceased lordship, and that private case was allowed. Then the appeal was filed. So in the appeal lordship, this judgment was delivered by the Honorable Justice Devassis Borua. Lordship, may be pleased to come to para 6, page 3, para 6. This is the latest judgment of 21st of July 22.
Yes.
Para 6. It is pertinent to mention that on a perusal of the written objection would not disclose any manner that there was any suspicious circumstances leading to the execution of the said will by the testator. The report further shows that pursuant to the filing of the said written objection, the said probate miss case number was registered title suit number on 26/6/12. The court below framed as many as 4 issues, then issues were framed. Then a lordship may be pleased to come to para 7. The report further reveals that on 26/9/13, the plaintiff filed evidence on affidavit of 4 plaintiff witnesses and exhibited various documents. Thereafter, it appears from the perusal of the order dated 25/8/14 that the said probate title suit number was renumbered as probate case number descending. This further appears that the defendant adduced the evidence of 2 witnesses who were the defendant number 1, Sri Deepak Dheka, and 1, Srimati Dayavanti Das, who was the defendant witness number 2. The witnesses upon being
Where the will was executed?
Pardon?
Where the will was executed? In whose house?
Lordship.
In whose residence the will was executed?
Will was executed in the house of Nirvendra.
But your witness, PW3, during his cross-examination, has stated that it was executed in the house of.
It is not correct. It is not correct. I will place that.
But it is your witness.
Lordship, it was a ancestral property. Father of the party's lordship, Mohini Goswami Thupan, had constructed that house at Gauhati.
You come to page 86 of the
Page
86 of the memo of appeal. Cross-examination of PW3 Siddhartha Datta.
Page 86, Lordship.
In the middle part, when I went to Gauhati, residence of Birendranath Fukal.
No, here. Which line, Lordship?
10th line.
10.
When I went to Gauhati residence.
First, there is sign of the will. Yes, Lordship.
When I
have
went to
never-
Guwahati residence of,
I have never informed Virendra
next line,
this will.
next line.
The execution of the said will Rajendranath Sharma, Minal Das, was not known to me.
Now
When I
this
went-
line, when I went to Guwahati.
Yeah. When I went to Gauhati residence of Virendranath Phukan, two more present were already present. One of them was writing to the will. This is because this is a joint property lordship. All the three brothers used to reside whenever
But he
Nipendranath.
says that it was in the residence of Biren Fukan.
That I'll place. Other documents are there.
Okay.
Because the Virendranath Phukan, he was regularly residing. Nipendranath also, whenever he come to Gauhati from Jora, he also resided in the same house. And whenever Devendranath Phukan, that is the appellant lordship, come from Ireland, he also used to reside there. Lordship. So it was at that time it was a common house, common ancestral property lordship. One may call the house of the Virendra Phukan, one may say house of the Nipendranath Phukan, one may say house of the Devendranath Phukan. It does not mean that the will was executed. It was executed in the actual position in this lordship. This statement is not correct. I'll place those documents, how the will was executed, where it was.
Okay. Yes, you come to the judgment.
I was placing the judgment of the Honorable Justice. Lordship, para 7. That the report further reveals that on 26/9/13, the plaintiff filed evidence on affidavit of four plaintiff witnesses and exhibited various documents. Therefore, it appears from the perusal of the order dated Itna that the said forfeit title sheet number was renumbered and stated said forfeit case number is said. It is further.
No, what you want to show from this judgment?
Lordship.
What you want to show?
Operative part, Lordship, it has been held that once the defendant who has filed the evidence and in the cross-examination, he has admitted that the will is genuine and it was executed by the mother of the parties here, a respondent.
No, in the instant case, though he has admitted the signatures, he is disputing the genuineness of the will. He has not stated that the will is genuine. He has stated that the witness is of
He has
Nipender.
stated that the signature appearing on the will
Is of,
signature of
yes,
Nipender.
yes, that he has admitted.
So then, Lordship, what are the pleadings of the appellant defendant in the objection that the will was manufactured, signature was taken on the blank paper? These are the averments, Lordship.
Yes, yes.
So see the contradictory statement taken by the appellant defendant, Lordship. Objection says something, evidence on affidavit says something, cross-examination says something.
Okay.
I will be allowed to read. This is very one of the leading judgment of Lordship.
Yes.
Private. Witnesses upon being cross-examined, the trial court.
Which para you are reading? Which para?
Para, Lordship, 1, 2, 3, 4, 5, 6. Para 7.
Okay.
Para 7, Lordship. Line 1, 2, 3, 4, 5, 6, 7, 8. Line 8. The witnesses upon being cross-examination. Lordship, got it?
Yes. Yes.
Cross-examined, the trial court by the judgment dated so and so decreed the forward the suit in favor of the plaintiff. In doing so, the trial court held that the petition for forfeit filed by the petitioner was maintainable. While deciding the issue number 2, the trial court, after taking into account the various evidences as well as the preposition of law relating to grant of forfeit, came to a finding that the plaintiff had successfully established by cogent evidence that the testatrix had affixed her thumb impression on the will as per her own volition on 14/16 at Gauhati, having understood the nature and the effect of the disposition. It was further held that the defense failed to rebut the evidence of the plaintiff side, and in absence of any cogent materials on record to indicate existence of the suspicious circumstances surrounding the execution of the will, the genuineness of the will cannot be doubted. Then para 10. Mr. R.K. Jain, the learned counsel for the appellant, submits that the trial court did not take any did not take into consideration the notary before whom the purported will was executed was not examined. He further submitted that the trial court did not take any consideration in the proper perspective that in the proposed will there is no mention of the testatrix has required the witnesses to put their signatures. The learned counsel further submitted that the death of the testator on 14/7/10, just 1 month after the execution of the will, and that she was suffering from various ailments during the period, gave rise to a suspicious circumstance regarding her mental and physical health, which was not properly taken into consideration by the learned trial court. Para 11, it was further submitted that the manner in which the proceedings were conducted also could show that the plaintiff was trying to get the will probated by hook or crook, referring the evidence on the affidavit cum NOC filed on behalf of the defendant number 1 and 2 on 10/1/2000 exhibit as exhibit 4 and 5, when the date was not fixed for filing the evidence, clearly show the intent of the plaintiff. He further submitted that there were 4 issues framed by which the trial court has only given findings as regard the 2 issues, which was contrary to Order 14 Rule 2 of the CPC, which mandated that the trial court has to decide on all the issues. They further submitted that the non-examination of the notary public service whom the purported will also execute is fatal, taking into account the testator had to put her thumb impression before the notary public further to the advocate who identified the testatrix was also not examined. Para 12. On the other hand, Mr. S.P. Roy, the learned counsel, appearing on behalf of the respondent, submit that the perusal of the written objection as well as the evidence of the defendant would neither suggest or show in any manner that there are any pleadings to effect that the testator was not capable of executing the will on the ground that she was mentally and physically not capable of the further submission, that they submitted that the evidence on affidavit from NOC were duly.
Now, Mr. Roy, what you want to show from this judgment? How it will help you?
My lord, the facts of the present case and the judgment are ditto similar. There also, the defendant admitted in the WS and the cross-examination that the signature appearing on the will is of the testator lordship.
Okay.
Subsequently, he continued to contest lordship. So this has been dealt in a much better way, lordship. I will be allowed to place law. Only at 11 courts.
Yes.
Para 12. On the other hand, so the learned counsel, appearing on behalf of the respondent, submits that on perusal of the written objection as well as the evidence of the defendant neither suggests or show in a manner there are any pleading to the effect that the testator was not capable of executing the will on the ground that she was mentally and physically not capable of. He further submitted that the evidences on record and NOC were duly given by the defendant number 1 and 2, which were exhibited as exhibit 4 and 5, wherein they had only admitted that the fact of their knowledge that that their mother had executed will in favor of their sister in connection with the property which fell in the share of their deceased mother after partition. it was mentioned in the evidence on affidavit that NOC that had no objection of the court granting probate or letter of administration in favor of the sister of the estate. Other parts I am skipping. Lordship may please put on to para 30. That in order to dispel the suspicious circumstances so raised for the first time before the appellate court, the learned counsel submit that a perusal of the will in question would show that the property therein had been bequeathed in favor of the daughter of the testator and not to any other person. Referring to the exhibit 3, which is the deed of family settlement, the learned counsel submit that a perusal thereof, which have been duly admitted by the defendant as a genuine document during the cross-examination, would show that in the said deed of family partition, no property had been given to the daughter of the testator, who was also had an equal share in respect to the property left behind by a father. And it is under such circumstances that the mother, that is the testator, had bequeathed a portion of the property in favor of her daughter. On the question as regard the non-examination of the notary public or the advocate who had identified, he submit that the writ can be executed and that the will can be executed by the testator or the testatrix on a piece of paper. It is neither required to be registered, not even executed before the notary public. What is required is only conformity with the provisions of section 63 of the Act of 25 and filing of the application in terms with chapter 4 of the part 9 of the Act of 1925, that is Indian Succession Act. Para 40. As regard the statements made by the learned counsel for the appellant that the impugned judgment is not in conformity with the order 14 rule 2 of the court, the learned counsel for the respondent submitted that on perusal of the judgment passed by the trial court would show that all the issues have been addressed, and as such the question of non-compliance of the order 14 rule of the CPC does not arise. He further submitted that it was only the defendant, one, who for vested interest had objected to probating the last will of his mother, and this would be apparent from the fact that the defendant too had not come before the court to give evidence nor filed any appeal against the judgment impugned in the instant proceeding. There is also no mention in their pleading as in the evidence of the defendant number 1 about the health issues of the testatrix, nor any material evidence has been placed on record to show that the testatrix was suffering from ailment, which incapacitated the testator to execute the will in question. Under such circumstances, the learned counsel therefore submitted that the filing of the instant appeal is nothing but to delay and deprive the sister of her legitimate rights in respect to the property bequeathed to her by her mother, for which the appeal is liable to be dismissed. Their lordship, next page, para 16. For determination of the above point, for determination, it is required to analyze the legal principle applicable to the making of a testamentary document like will, its proof and its acceptance by the court. The will being a rather solemn document that comes into operation after the death of the testator. Special provisions are made in the statute for making a will and for its proof in the court of law. Section 59 of the Act of 25 provides that every person of sound mind, not being a minor, may dispose of his her property by will, a will or any portion of the will, the making of which has been caused by fraud or portion or by any such important that has taken place. Free agency of the testator is declared to be void under Section 61 of the Act of 1925. Section 62 stipulates that the will is liable to be revoked or altered by the maker of it only at any time when she is competent to dispose of his or her property by will. Chapter 3 of Part 4 of the Act of 1925 contains the provisions for execution of the unproven will. The said chapter has two provisions of section 63 and 64. Section 63 being relevant for the purpose of the instant dispute. This same is quoted here in below. Then section 63 has been quoted. Lordship. Then your lordship may come to para 17, page 10. Perusal of the above quoted section would show that it is the requirement of the law that the will ought to be attested by two or more witnesses. Hence, any document propounded as a will cannot be used as evidence unless it is at least one attesting witness has been examined for the purpose of proving its execution. In such, if such a witness is available and capable of behaving this, as per the requirements of the section 68 of the Prohibitions Act, that reason follows. Then lordship, section 68 has been quoted. Then I am placing para 80. The above quoted section 68 deals with proof of the execution of the document required by law to be attested, and it proves that such a document shall not be used evidence until one attesting witness has been called for the purpose of proving the execution. In the present case, lordship, two attesting witnesses has deposed that yes, the executor has signed the will in their presence. The said provision prescribe the requirement and the nature of the proof which must be satisfied by the party who relies on a document before a court of law. Therefore, section 59 and section 63 of the Act of 25 are of a final significance in section 59 provide that every person of sound mind not being a minor may dispose of her property by the will. And the three illustration in the said section indicate what is meant by the expression a person of sound mind in the context. On the other hand, section 63 requires that the testator shall sign or affix or mark to the will, or it shall be signed by some other person in a presence and by the discretion, and that the signature or mark shall be shown that it shall appear that it was intended thereby to give effect to the writing as a whole. The section also requires that the will shall be attested by two or more witnesses as prescribed. This thus the question as to whether the writ will set by the propounder is proved to be the last will of the testator has to be decided in the light of this provision. Para 90. The question therefore which have to be in the mind of the testamentary court are: has the testator signed the will? Did the understand the nature effect of the deposition in the will? Did he put his signature in the will knowing what is content stated broadly? It is the decision of this question which determine the nature of the finding on the question of proof of the will. At this stage, it may not be out of place to mention that Order 6 of the Act of 25, Section 74 to 111, for construction of the wills which in their sum and substance make the intention of the legislature clear that any irrelevant misdescription is not to be operate against the will, and the approach has to be give effect to the will once it is found that it has been executed in a sound state of mind by the testator while exercising his or her will. What calls out, para 20, what calls out therefore, therefrom, it is the is that the will has to be proved like any other document except as to special requirements of the attestation prescribed by section 63 of the Act of 20. As in the case of proof of other documents, in case of a proof of will, it would be idle to expect proof with mathematical accuracy. No doubt, section 67 of the Indian Evidence Act has also to be taken note of which stipulation that if a document is alleged to be signed by any person, the signature on the said document must be proved to be in his handwriting, and for proving 47 of the act, the opinion of the expert and the persons of the acquainted with the handwriting of the person concerned are made relevant. Therefore, the test has to be applied with the usual test for satisfaction of the prudent necessity. Though in the present case, Lordship, the appellant have made averment or submitted Lordship, the executor of the will was not in the sound. But he has not proved any document, Lordship, not exhibited any document that he was suffering from any serious illness. He was not a state of mind and health, Lordship, nothing. We are making averments, Lordship, that he was suffering from various ailments. He was not in a capacity to decide. He did not understand the contents of the will, Lordship. Will not do. Burden lies upon the person who challenges the will to prove why a doctor was not called by a witness in on Lordship on behalf of the appellant defendant who has treated late Nirpendranath Bhupan to prove the allegations of the mental illness or incapacity. That duty has not been discharged. Para 21, that it is a important one thing more. In the affidavit, Lordship, the appellant has stated that he had some medical documents of Bhupan, but he has not produced. He has not produced it. Para 21, that is an important distinguished feature between will from other document. Unlike the other document, the will speaks from the death of the testator and so when it is propounded or produced before the court. The submission of my learned friend that why the beneficiary was not in. Why the executor will inform? During his lifetime, he may change, he may make 100 wills by cancelling the other, revoking the other will. And so it was propounded or produced before the court. The testator had already departed the world, for which he cannot say whether it is his her will or not. And this aspect naturally introduced in the element of solemnity in the decision of the question as to whether the document propounded is proved to be the last will and testament of the departed testator. Even so, in dealing with the proof of will, the court will start on the same inquiry as in the case of a proof of the document. The propounder would be called upon to show by satisfactory evidence that will was signed by the testator, that the testator at the relevant time was in sound and disposed state of mind, and that she understood the nature and the effect of the deposition to the document of his on the will. Ordinarily, when the evidence adduced in support of the will is disinterested, satisfactory, and sufficient to prove the sound mind and disposing state of mind of the testator and his her signature as required by law, court would be justified in making a finding in favor of the propounder. In other words, the onus on the propounder can be taken to be discharged on proof of the essential fact just indicated. Then Lordship will come to para 25, page Lordship 50.
Yes.
Para 20. In a recent judgment of the Apex Court rendered in the case of so-and-so 2021-11 SSC 227, the Supreme Court laid down the relevant principle governing the adjudicating process concerning the proof of the wills in paragraph 12, which is quoted below. Then the Supreme Court judgment has been quoted, Lordship.
Yes.
Lordship, very pleased to come to page 80, para 26. Para 20. In the backdrop of the above, let this court therefore take into consideration the facts of the instant case. The will in question has been exhibited as Exhibit 2. On perusal thereof shows that the testatrix had put her thumb impression on the will. The said document was signed in presence of three witnesses, namely Rajendra Kumar Sharma, Shri Vipul Das, and Shri Anup Kumar Talukdar. The testatrix was identified by one advocate, namely Ajit Kumar Sharma. Therefore, the will in question is in conformity with section 63 of the Act of 25, para 27. Now the question arises as to whether the will in question was executed by the testatrix in her sound mind. In the evidence of the propounder of the will, that is BW1, it was mentioned that the writer of the will, Mathur Chandra Bayan, had read over and explained the contents of the will to his mother-in-law as she was illiterate. Thereafter, upon understanding the contents of which she had executed her said last will and testament before the notary on 14/6/2010 in presence of the attesting witnesses, Shri Rajendra Kumar Sharma, Shri Vipul Das, and Shri Anup Kumar Talukdar, and others. Nothing could be brought on record during the cross-examination that the testator was not capable of making the will or was incapacitated mentally or on account of physical ailment to execute the will. In the written objection, the stand taken by the defendant number 1 and 2 was specific. It was mentioned that the will in question is a forced manufacture and got up document by the illegal beneficiaries and the petitioner plaintiff in order to take advantage of the helpless condition of the answering defendant. To the said effect, evidence have been laid. Para 28. Both in the written objection as well as in the evidence on affidavit of the defense witnesses, there is no mention whatsoever that the testator was not capable of executing the will for reasons that she was not of sound mind. The only allegation is that the will is a forced manufacture and got up document. At this stage, if this court take into consideration the provision of Order 6, Rule 4 of the court, it will be seen that in all cases in which a party pleadings relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence in all other cases in which particulars may be necessary beyond such as are exemplified in the forms. Particulars with dates and items, if necessary, shall be stated in the pleadings. Order 6, Rule 2 of the court stipulate that every pleading shall contain a statement of the material fact on which a party relies upon, either for his claim or defense. Such a pleading should contain the necessary foundation for raising an appropriate issue. Under Order 8, Rule 2 of the court, a defendant shall make specific pleadings, while under Rule 3, Daniel should be specific. Therefore, it is the requirement of the law that if the fraud is pleaded, there has to be a specific pleading with material particulars in either the clause or the defense. However, there is no specific statement made or particulars given as to why the defendants state that the will is questioned in the force, manufactured and got up document. Already, as earlier in the judgment of the Supreme Court in so and so, it was observed that if a person challenges the will, alleges fabrication or alleges fraud, undue influence, coercion, or in regard to the execution of the will, such plea have to be proved by him. At this stage, it may also be relevant herein to take note of the Exhibit 4 and 5 which were the NOC come evidence on affidavit sworn by the defendant number 180. The execution and the signatures in respect of the exhibit 4 and 5 were duly admitted during the time of the cross-examination. In exhibit 4 and 5, the defendant wanted to have categorically admitted that the mother had executed the will in a question and bequeathed her share of the property in favor of her daughter. Another very relevant fact which needs to be taken into consideration is that the written objection was filed much later to the evidence on affidavit from NOC. But there is no mention in the written objection relating to the said evidence on affidavit from NOC to be forced or executed into portion. The court cannot overlook the fact that the defendant number 2 has not entered the witness box to deny the execution of the exhibit 5 as well as have not filed any appeal against the judgment imposed in the state appeal. Under such circumstances, the allegations of fraud or that of the will was manufacturingly cannot be said to be true. Para 29. Be that it may be, it is also relevant to take note of the will in question. The entire property left behind by the testatrix was vacated in favor of the daughter. The question which needs to also be looked into as to whether the same could come within the ambit of these suspicious circumstances. In a very recent judgment of the Supreme Court, in a reported 2001 SCC 1 on 5, the apex court observed that the testamentary court is not a court of the suspicion, but that of conscience. It has to be considered that the relevant material, instead of adopting an ethical reasoning, it was further observed that a mere exclusion of either a brother or sister per se would not create a suspicion unless it is surrounded by other circumstances creating any interference. Paragraph 25 of the judgment quoted. And ultimately, Lordship, operative portion, last page, Lordship, the appeal was dismissed by the Honorable Justice of the Government. The court of the opinion that the informed judgment decree passed by the trial court issued does not suffer from any infirmity in law for which the judgment decision is passed. Lordship, here only allegations are that the will was manufactured. It does not have the signature. Sometimes it does not have the thumb impression, Lordship. But what was the main physical condition, Lordship? How he was not in a capacity to execute the will, Your Lordship. No piece of paper has been produced by the appellant defendant, Lordship. Mere the averments in the air will not do, Lordship. So this judgment is very important judgment on the question of granting or refusing the probatives. Now, when it be taken on Thursday, Lordship?
No,
I am
no,
tired.
we have to complete it today.
Complete on Thursday.
How, what remains?
There remains so many things.
So many things.
I am badly tired. Or tomorrow. My learned friend has taken 2 days.
So you also take 2
The
days.
same opportunity.
I will reply to whatever he has replied or tomorrow.
I have to submit. Tomorrow I am ready to.
Okay.
Tomorrow or day after.
On Thursday. Third Mr. B.D. Das. B.D. Das, learned senior counsel assisted by Mr. H.K. Sharma, learned counsel for the appellant. Also Mr. S.P. Roy, learned counsel for the respondent. Though the matter was substantially heard, however, on request of learned counsel for the respondent. Further hearing is adjourned for the day. Let this matter be listed as part heard matter.
Tomorrow at 2 p.m.
No, at
2 p.m.
day after tomorrow, hearing day. Day after tomorrow,
All right.
at 30 July. As the first hearing item?
Yes.
No, at 2 p.m. At 2 p.m.
Yeah. Hey, I know that.
Much obliged.
எல்லாம் mix பண்ணி அவ்வளவு
Separate file.
May I please, your lordship? Chief, I have taken some information. It has been fixed on 10/8 for production and evidence, but there is no public prosecutor. And there is no information as to when the learned public prosecutor is going to join.
No, registry has taken some steps. We will issue directions to let this court know. Because your main plea is that the trial is halted. It is not proceeding.
Absolutely not.
Heard Mr. A. Bhattacharya,
Why, your lordship?
Bhattacharya, learned counsel for the petitioner. Also heard Mr. K. K. Das, the learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner, namely Sohin Basumatari, who has been detained behind the bars since 26/3/2025, within bracket for last how many days?
410 days, lordship.
For last 410 days, in connection with NDPS case number
249 of
249
2025.
slash 2025, corresponding to Nunmati PS case number 64 slash 2025, under section 20 within bracket small b within bracket small 2 within bracket capital C of the NDPS Act 1985. The aforesaid case is pending before the Court of Learned Special Judge NDPS
Kamrup Metro.
Kamrup Metro. Learned counsel for the petitioner has submitted that the main ground on which,
There are other grounds also, lordship.
though there are several grounds,
This is one of the grounds.
however, the main ground on which the petitioner is seeking bail is that the trial of the NDPS case number 249/2025 is not proceeding before the trial court due to absence of special public prosecutor. Since when it is not proceeding?
18/5/26 was the last date, lordship. It has been recently, it was earlier pending in the court of additional district judge number 1.
Stop.
There the proceeding was going on. All of a sudden, on constitution of this new court, it was being transferred.
He submits that earlier the aforesaid case was pending before the Court of Learned Additional Session Judge number 1, Kamrup Metro, when the trial was going on at its normal pace. However, after constitution of special NDPS court, the aforesaid case has been transferred to the special NDPS court, which does not have any special public prosecutor, and therefore the trial pending before the said courts are not proceeding. So, you have any submission?
I have only one information that lordship, I have seen that I have asked my PP lordship They said all are appointed. I don't know why there is no.
None.
But every state appointed lordship in Kamruk Metro also. Otherwise, lordship section 37 is attracted here because commercial quantity is there. And independent witnesses are also integrated.
On the other hand, learned additional public prosecutor submits that commercial quantity of contraband is involved in this case.
No, in that case, Lordship, I
And-
will pray that Lordship may kindly take it on some other day for an argument.
No. Let me call for a report short.
Request. Lordship.
Special in the last line. Commercial quantity of contraband is involved in this case, and as such, the embargo of section 37 of the NDPS Act is applicable to this case. Stop. I have considered the submissions made by learned counsel for both sides. The main contention raised by the learned counsel for the petitioner, that is halting.
Main contention, Lordship, is non-adherence to the NDPS Act. This we come to know regarding the halting, we have come to know after filing of this petition.
Okay.
So that is not taken as a ground here, Lordship. Main petition is 47 BNSS.
Though, cut it up last. Though in the instant bail application, the petitioner has taken several grounds for seeking his release on bail in the aforesaid case. However, the submissions made by learned counsel for the petition regarding non-availability of any special public prosecutor before in the court of learned special NDPS court, in the court of learned special judge, special court, NDPS court.
NDPS. Special designated court, no?
What is the exact designation?
Special Judge, NDPS, Kamruk Metro.
In the court of learned special judge, NDPS Kamruk Metro is a very, and the Kamruk Metro, and as a result of which non-progress of trial any further is a very serious matter which cannot be ignored. Though the embargo of section 37 is applicable to this case, however, if the trial does not proceed for the fault of the state to appoint a special public prosecutor, the petitioner may perhaps get the benefit of bail due to violation of his fundamental right under Article 21 of the Constitution of India regarding speedy trial of his case. Stop. As such, in the aforesaid circumstances, the registrar vigilance of the registry of this court is hereby requested to get an up-to-date information from the LR Secretary, Judicial Department to the Government of Assam regarding the status of appointment of special public prosecutor in the Court of Learned Special Judge, NDPS.
Yes, Learned Special Judge, NDPS, Court, Assam, Gauhati. It is
NDPS
written
Court, Assam, Gauhati,
Assam, Gauhati. Is written
on or before the next date fixed. Let this matter be listed when the next date is fixed.
Next date is on 10th of August, actually.
Let it be before 10th.
14th. 14th of last year. 14th, 13th or any after day after 15th, Lordship. आठ में पड़े जाए
18th.
18.
Let this matter be listed again.
Some correction, Lordship. He is behind the bar for 491 days.
491 days.
91. I'm declared.
List accordingly.
11 to 18.
11 to 18.
My pleasure, Lordship. My lord, there are 18 cases already been listed, my lord. There is against the same continuing claim application, two appeals are there. One is the appeal filed by the railway, another filed by the respondent. It's a cross appeal. So my lord, I make one head note, the which item is related with each other. Item number 11 is related to 17 and 13 is related to 15. 12 is
Just a
related
minute.
to 18.
Just a minute, Mr. Chakravarti.
Yes, ma'am.
Slowly. 11 is related to?
Yes, ma'am. I'm giving my
You have a-
handwriting note, my lord.
Others are not related.
Other than fact of the case is the same, but these again the same way. OA number 26 of 2016, there are two cases. One appeal is filed by the
Then
railway.
why all these cases are listed to?
Where railway challenged the impugned judgment of this RCT manner, and they have filed this cross appeal for enhancement of the interest on the said judgment. So, my lord, there are two appeal in the same way. Item number 11, MFA 15 of 2019 is OA number 26 of 2016, and item number 17, MFA 180 of 2019 is OA number 26 of 2016. This is the cross appeal. Then item number 13, MFA 27 of 2019, OA number 29 of 2016, and item 15, MFA 165 of 2019, OA number 29 of 2016. Same way, this is MFA 165 of 2019 is a cross appeal filed by the respondent for the enhancement of the interest. The RCT granted interest at the rate of 6%, they are claiming 12%. With the same for all the cross appeals already been dismissed by this honorable court. There is no question of the enhancement of the interest against the RCT's order. Then item number 12, MFA 16 of 2019, OA number 31 of 2016, and the MFA 18, item number 18, MFA 193 of 2019, OA number 31 of 2016, same way. And this is the cross appeal. Item 14 is related to item 16. MFA 59, 2019, against the OA number 28 of 2016, and MFA 180 is also related to the OA number 28 of 2016. This is the cross appeal.
So we'll take up first matter 11 and 17 today.
Yes, my lord.
11 and 17 we
Yes.
hear today. Others we will group according to what you have suggested.
Yes, my lord.
You are appearing for 11.
11 and 17, my lord.
Yes, Miss. What-
11 is, my lord, is filed by the railway, challenging the impugned judgment, common judgment dated 39/2018, passing
Just-
way number
just
26 of
Miss
2016.
Sharma,
MS Sharma.
what is your name?
M. Sharma.
Yes, Miss Sharma. Today we will hear item number 11 and 17.
Yes, my lord.
Rest matter will detach from this group.
Actually, where all the matters were arising out of the same common judgment. That's why these matters.
Oh, common judgment.
Yes,
Yes, my lord.
that's
Common
why
judgment.
these matters are tagged together.
But facts are different.
Though facts are different, there are 5 claim applications which were decided by the learned tribunal. Out of 5, lordship, one case has been disposed by the Honorable Gauhati High Court in MFA number 12 of 2019. one order has been passed by this honorable court lordship. The balance 4 cases are listed along with the cross appeals. Lordship.
No, actually, as per there is some rule 24 of Railway Claims Tribunal rules.
Yes.
Some
Lordship, facts are different, but the issue is with regard to
but
refund of
a common judgment cannot be passed if facts are different.
Yes, my lord.
Unless facts are same. Railway Claims Tribunal.
date of booking and all is different, Lordship, but
So, if Railway Claims Tribunal Act.
Claims Tribunal Procedure Rules.
Act consult dilemma. Act আছে তো। Act here. Act of consult.
Rules, my
Yes,
lord.
read. No, Railway Claims Tribunal Act. Rule 24 says when two, yes, you have the act. Read.
where two or more applications pending before a tribunal arise out of the same facts.
Same
and
facts and that means first there have to be same fact.
Same fact.
Plus
Plus
issues have to be similar.
Any issue involved is common.
Yes.
Your Lordship, facts are not same, but
Then,
issues are common.
but then there cannot be a common judgment. For passing a common judgment, both these conditions are to be fulfilled. The Railway Claims Tribunal has passed a common judgment disposing of about 45 so cases.
Yes, ma'am.
Whether that can be done. Because Rule 24 clearly stipulates two conditions which are to exist together. Same facts and common issues.
Common issue.
Merely because common issues are there with different facts, you cannot club all the cases.
But this plea was not taken by them at the time of filing of their written statement, Lordship.
No, but
So,
this is a
their Lordship.
legal requirement.
Provision is there.
Still, we'll hear the item number 11 and 17.
Let this appeal be detached, Lordship. If Lordship,
All appeal may be separated, my lord.
Yes, all will be.
Yes, my lord.
We will separate
Yes,
it.
but whatever I've given my hand note, my lord, 11, 17. And
Yes, in that manner they may be clubbed.
yes, my lord.
Appeal and cross objection may be clubbed.
Yes, my lord.
So, are you ready for hearing, making submission in 11 and 17?
Yes, my lord. My lord, in this case, my lord, I have already prepared my written argument, my lord. If lordship permit me, I can submit it, my lord.
Yes.
I stated the brief fact of the case also and the points of argument in both the cases, my lord.
You will not make any oral submission. Brief. Have you also prepared written?
yes, Lordship. But I would like to make oral submission.
Okay, yes.
So, my lord, in this order submission, we are challenging the impugned judgment and order, common judgment order dated 39/2018, my lord. In 11, item 11. Here, the appeal is be prepared for challenging the legality validity of the common judgment and order dated so and so whereby learned RCT allowed the claim of the respondent even claim application way number 26 of 2016 and where the claimant claim rupees 1 crore 47,13,881. The RCT is granted 70,73,981 along with the cost of rupees 25,000 imposed as extra cost by ignoring the various provisions of the Railway Act, Railway Claim Terminal Act, Railway Claim Terminal Procedure Rule 1987 as applicable. The consignment of the petroleum was booked from Numaligarh siding station to Bantara, BTRA, which is in Uttar Pradesh, Shahjahanpur district, Murdabad division, my lord. Bantara is total 4084 RR with effect from 16/9/2006 to 4/3/2007, which are reflected in internal page of the impugned common judgment 13/9/2018 and page 15 of the appeal under ON number 26 of 2016. Here, my lord, I have taken in my ground various grounds, my lord. Page number 5 of memo of appeal. The appellant has proved by filing evidence on affidavit to the effect that Railway Authority had never worked out, prepare any overcharge sheet in the form of LS certificate statement dated 3/1/2009 as claimed by the respondent. However, the learned tribunal, having failed to consider the said aspect of the matter, caused various error of law. Hence, the judgment in question is liable to be set aside. Ground number 7, for that respondent had failed to prove by producing any documentary evidence or relevant record from before the tribunal showing collection of the alleged excess freight by the railway, despite the learned tribunal having failed to consider the said aspect of the matter as caused grave error of law. Hence, the impugned judgment in question is liable to be set aside. To open my ground number 11, page 6 of my memo of appeal. For that, Railway Authority had never worked out prepare any overcharge sheet in the form of LS certificate statement as claimed by the respondent. The said fact has also been brought on record by of evidence on affidavit. However, the learned tribunal, having failed to consider the said aspect of the matter and caused grave error of law. Ground number 12. For that, respondent had relied on a letter dated 11/8/2006 as respondent's documents number 1 enclosed with the claim petition. By this letter, the respondent had made a categorical admission to the fact that due to the various reasons like commission of new line, removal of inflated distance due to bridge barrier, etc., there has been a change of distance between junction to junction. And in view of the said circumstances, a request was made to provide the current and update distance chart from the Chief Commercial Manager Railway for the consignment which are likely to be booked. However, the learned tribunal, having failed to consider the contents of the said letter, admission on the part of the respondent has caused grave error of law and has the impugned judgment liable to be set aside. Ground number 13 at page 7. For that, respondent had relied on the railway's letter dated 31/7/2008 as respondent document number 3 enclosed with the claim petition. By this letter, railway had admitted the distance between Numaligarh to Ranchi to be 1443 km instead of 1378 km, which was wrongly reflected in this letter dated 5/9/2006, and accordingly same was corrected. However, the railways by letter dated 31/7/2008 had never informed anything about the distance between the remaining station as reflected in the earlier letter dated 5/9/2006. The learned tribunal, having failed to consider the contention of the said letter and has caused grave error of law, and hence the judgment in question is liable to be set aside. Ground number 14, further the respondent relied on Railway's letter dated 1/12/2008, respondent's enclosure number 6 to the claim petition. The railway had issued the aforesaid letter showing distance of 5 stations from Numaligarh NMGS, which was in response to the applicant's letter under memo number so-and-so dated 28/11/2008. The distance reflected in the letter dated 1/12/2008 was the distance prevailing at the relevant time, and it had nothing to do with the distance prevailing in the year 2006. However, the learned tribunal, having failed to consider the content of the said letter and has caused grave error of law. Ground 15, for the respondent had relied on the railway's letter dated 16/12/2008, respondent enclosure number 6 to the claim petition. By this letter, railway had rectified the distance for 4 stations, namely from Numaligarh siding to Hisar, Bijwasan, and Kathar Singhawala and Bhatinda, respectively. However, distance from Numaligarh to Banthara remains the same. Thus, by this letter, railway had corrected the clerical mistake appeared in the railway's letter dated 1/12/2008. However, the learned tribunal, having failed to consider the contents of the said letter and caused grave error of law. Ground 16, for that the consignment in question, the railway had never admitted anything about the collection of the freight on incorrect distance. That appellant had also failed to bring on record any material to show that the distance for which the railway had collected the freight was incorrect. And as such, question of errors refund does not arise at all. The net tribunal, having failed to consider the said aspect of the matter, has caused grave error in law. Hence, the judgment question is liable to be set aside. The ground number 617, for the respondent made a reference of various transactions without any specific detail, which can be termed a very casual and vague statement without any authentic document to support such claim. As such, the alleged claim is not maintainable. And then 18, the alleged statement stated to be prepared by the CGS and Numaligarh siding has already been denied by the railway by filing evidence on affidavit, and also denied under the provisions of Rule 15B of the RCT Procedure Rule 1987. And asked the respondent to prove the said fact. And as such, the respondent was duty bound to bring on record at least some material, but the respondent has failed to discharge the said burden, and hence the claim is not maintainable in law. And the learned tribunal failed to consider the said aspect of the matter and caused grave error of law. 19, railway letter dated 1/12/2008, the distance of 5 stations were informed to the respondent, which were prevailing at the said period of time. Thus, by this letter, railway had never rectified, corrected any distance by letter dated 5/9/2006. The distance which were reflected in the railway's letter dated 5/9/2006 were corrected in prevailing at the period of time, except the distance to Ranchi, which was subsequently corrected. And the applicant had also not raised any objection to such correction and paid the due amount to railway without objection. Similarly, by letters dated 16/12/2008, the classical mistake appeared in the railway letter dated so-and-so 1/12/2008 were rectified, and nothing has been mentioned in the letter in respect of the distance reflected in the railway letter dated 5/9/2006. Hence, the observation of the learned tribunal to the fact that the railway had rectified the distance reflected in the letter dated 5/9/2006 is not correct. Hence, the claim of refund was baseless. Hence, the learned tribunal, having failed to consider the said aspect of the same matter, has caused grave error of law. In the matter, my lord, in RCT, Bhatt decided the issue number, same three issues. The issue number 2, whether the applicant is entitled for refund of the freight overcharged by the respondents. Issue number 3, number 2, as per in page 24 of my memo appeal, issue number 2, as per written argument submitted by the respondent Railway's letter dated 1/12/2008 and closed as Annexure 6 to OA, showing distance of 5 stations from Numaligarh Junction siding was the distance prevailing at the relevant time, and it had nothing to do with the distance prevailing in the 2006. But by letter dated 16/12/2008, Railway had rectified the distance from Numaligarh siding to 4 stations, Hisar, Bijwansha, and Kachar Singhwala and Bhatinda, respectively. However, the distance from Numaligarh to Bhantara remained same. Thus, by this letter, Railway had corrected the clerical mistake that appeared in the Railway's letter dated 1/12/2008. So, for consignment in question, Railway had never admitted anything about the collection of freight on an incorrect distance. And the applicant has also failed to bring on the record any material to show that distance for which the Railway had collected a freight since 2006 was incorrect. As such, the question of alleged refund does not arise. The respondent has also submitted that as per the alleged statement showing refundable amount is concerned, which was prepared by the CGS Numaligarh siding. The same had already been denied by the Railway by filing evidence on affidavit, and also denied under the provisions of the Rule 15B of the RCT Procedure Rule 1987. And to prove the said fact, the applicant was duty bound to bring on record at least some materials, but the applicant has failed to discharge the said burden, hence the claim is not maintainable. During the course of trial, Railway had made an inquiry into the alleged certificate statement, and the competent authority had informed by letter dated 4/10/2016 that no such statement was prepared by Railway. Instead of proving the refundable amount, the applicant did not bring any material on record, and therefore the claim application of the applicant are not maintainable. As per the applicant, Railway identified their wrongs and admitted the correct freight changing distance, which is much less than the distance for which freight were charged by letter dated 1/12/2008. But the respondent in reply submitted that Railway had never admitted any mistake wrong in respect of distance. It was submitted by Railway's letter dated 1/12/2008. The distance of 5 stations were informed, which were prevailing at the time of issue of the letter. It was submitted that by letter dated 31/7/2008, Railway corrected the wrong distance, which was reflected in the distance letter dated 5/9/2006. Similarly, by letter dated 16/12/2008, the clerical mistake happened in the Railway's letter 1/12/2000 were rectified. Nothing has been mentioned in the distance reflected in Railway data dated 5/9/2006. Hence, the statement of the claimant to the effect that Railway had rectified the distance reflected in the letter dated 5/9/2006 is not correct. It was also submitted that distance from the station to station, keeping changing due to various reasons like commissioning new line, removal inflated distance due to bridge, barrier, etc. On the other hand, the applicant pleaded that refundable amount was worked out by CGS Numaligarh siding by certificate dated 3/1/2009, 6/12/2008 2012-2008, 5/12/2008, and 23/12/2008. Applicant also pleaded that they have been overcharged due to wrong calculation of distance, and applicant suffered loss of principal amount as well as interest. We have pursued the file and case record, and also during the proceeding, the respondent railway produced the presently posted CGS Numaligarh for a cross-examination for denial of the content of the excess freight calculated by CGS, Sri Pradeep Kumar Singh, CGS posted at Numaligarh. He filed an affidavit. In para 4 of this affidavit, he stated that NLR authority had shown me the Xerox copy of the statement which contains the signature of the then CGS Numaligarh Junction, now retired. I have no alternative but to put any signature on the said Xerox copy of the statement. In this said letter, to SCM Court, NF Railway Maligaon, he has stated that during the period from 2005 to 2008, computer system was not introduced at Numaligarh signing goods, and therefore the statement in question, which was applicant has relied on, might have been prepared by NLR authority. During the course of proceeding, applicant submitted a reply obtained by the learned counsel for the applicant from CPIO-105 and JDCTC Claims Railway Board under Right to Information Act 2005, wherein it is stated that as per available record, rule number 317.9123 of Indian Railway Conference Association Conference Rule Part 2 of 1972 is still in vogue, and have also included an attested copy of rule number 317.9 within bracket 1 to within bracket 3 regarding overcharge and claims. In clause 3 of this said rule, it is observed that to meet the cause of charge and well-formed firm, it may be arranged that such firm as are prepared to sign an undertaking to pay undercharge after delivery shall also be allowed to include in the same agreement an undertaking by the railway to refund all overcharges as soon as discovered, and the time limit of time being 6 months in earlier case. As stated above, the respondent railway collected undercharges rupees 98,35,378 in each case for the period 18/9/2006 to 23/7/2008, which are clearly beyond the period of 6 months. As a good gesture, the applicant paid the amount to the respondent railway, but when the applicant demanded refund of overcharge on the same basis for other 5 destinations as certified by them, the respondent denied the same on the ground of it being time-barred and hence not admissible. Despite resistance on the side of the applicant, the respondent railway denied that they have overcharged the applicant, and the distance charged during the period of 18/9/2016 to 23/7/2008 was not correct, and the letter subsequently written by the respondent railway to the applicant do not reflect the exact distance from the period 18/9/2006 to 23/7/2008. During the whole proceeding, the respondent has not brought any material on record to show the exact distance for their pair of points for the period 18/9/2006 to 23/7/2008. The applicant demanded the distance table by letter dated 11/8/2006, and all subsequent replies given by the respondent railway were based on this letter, which continued till 2008. The reply to the letter dated 11/8/2006 was furnished by the respondent railway by letter dated 31/7/2008, stating that the chargeable distance of goods tariff from Numaligarh to different destination are furnished by these letters of even number 5/9/2006, wherein the distance of Ranchi was shown as the 1378 kilometer via MLDT, means Malda ASN Asansol, which was wrongly shown instead of 1443 kilometer via same. The respondent has not brought any material on record to show that these distances were changed subsequently. If the respondent railway had recovered undercharge after 2 years, they should also been gracious enough to refund the undercharge due to applicant after correct distance were confirmed by them. Therefore, we hold that the freight was clearly overcharged by the respondent from the applicant, and the respondent railway is liable to refund the same. So, my lord, on the issue number 3, we have challenged this appeal by taking the various
By
grounds.
this common judgment, whether this common judgment is related to all the MFAs listed today. Other miscellaneous first appeals, item number 13, 15, 12, 18, and 14, 16. These are also related to this common judgment. Okay, okay.
Hmm. Hmm. Yes.
Yes.
My lord,
You have prepared the litigants for all the items.
in all the cases, I have prepared my written argument, my lord. In the cross appeal also, I prepared written argument. They are not entitled for enhancement of the interest, along with the various judgment of the Supreme Court and the High Court, my lord. So it is in my hand as well. If Lordship permit me, I can submit my lord.
Yes.
In item number 11 and 17. Item number 17.
Yes. What is, you have anything else to submit?
My lord,
Anything else?
in my written argument, I already explained, my lord, and the points of argument also I made here, my lord, along with the documentary evidence.
You have
which I
furnished a
like-
copy to her. Have you received a copy? How she will know? What is your submission?
Yes, I will furnish her.
What is
We
your
need copy.
response?
Actually, we are not giving any copy to any time because you are furnishing
If
before
they
this court, my
finish
lord.
it, then I can answer accordingly. Because I don't know whether they have taken the pleas beyond the pleadings or it is there in the pleadings, Lordship. So I
My
have to
lord,
check.
question of taking plea beyond the grounds, my lord, it does not arise. Because since I have filed the appeal, all grounds have been taken in appeal against the issue number 2, challenging the judgment of the RCT, my lord. And from this ground, I have prepared my this written argument. And points of argument also raised from this grounds also, my lord. A question of changing my submission and or contention or documentary evidence does not arise, my lord, because it is relied on the documentary evidence which I have taken in my ground and which is the RCT taken in this under issue number 2. That's also I have been annexed for the convenience of this honorable court, my lord. Otherwise, it will be difficult to find out from the LCR, my lord. Then it will, for the convenience of the court, my lord, I have annexed with my written argument. Whatever the written is. Item number 11. Item number 11, item number 17. Hmm. Mm-hmm. No. In my written argument, my lord, letter dated 11/8/2006, which delayed by the railway, I annexed Annexer 1 and Annexer 2, letter dated 5/9/2006, which is they claiming we have corrected. But aforesaid letter dated 31/7/2008 also annexed here for the convenience of the Honorable Court, my lord. And letter dated 28/11/2008
Ms.
issued
Sharma.
by the respondent.
What is your submission? What is your submission?
Lordship, first of all, in this judgment, Lordship, there are total 5 claim applications which were preferred before the Learned Claims Tribunal, Railway Claims Tribunal, which is arising out of the common issue, Lordship. So out of 5 claim applications, 1 claim application has been disposed of by this Honorable Court in MFA number 12 of 2019. The judgment I have furnished to you, Lordship. Just a few minutes.
Yeah. My lord, in my cross appeal, cross appeal MFA 188, I have annexed this judgment, my lord, MFA 12 of 2019. When, my lord, as per judgment, my lord, it is revealed that I have not admitted. But later on, findings of the court is that I have admitted. So, my lord, I already approached the railway. They will take steps. Now they said they already whatever they will take steps, my lord. Here, my lord, in my written argument in MIP 188 of 2019, item number 17, the page number 51. I annexed this judgment, my lord. On so far, in enhancement concern has been dismissed.
Okay, let us submit.
There, our MFA was the
79.
page, my lord, 49 of my written argument in MFA 188 of 2019. Item number 17, my lord.
Yes, what you want to say?
Yes, my lord. Item page number 49 of my written argument.
Yes, Ms.
Yes, but I have not conciliate because already the Honorable Court at the time of hearing, they have a contention of the appellant in MFA number 12 of 2019, which we have railway challenged. Dear my lord, in the contention of the MFA 12 of 2019, page number 51, the internal page of the judgment is 4. Paragraph 5. Agreed by the judgment in the main claim application OA number 27 of 2016, the railway appellant filed MFA 12 of 2019, contending inter alia on the grounds that the appellant, by filing evidence on affidavit, had proved that the railway authority has not prepared the alleged computer printed certificate statement as claimed by the respondent, in such much as the computer system was not placed during the relevant period of 2008. That point in this case also I have taken, my lord. That the NRL relied on the railway's letter dated 1/12/2008. However, the distance reflected in his letter dated 1/12/2008 was the distance prevailing at the relevant time, and it had nothing to do with the distance prevailing in the year 2006. They are claiming that in the 2010, 2008, whatever they have collected on the distance, it is wrong. We have to collect on the basis of the distance calculated in the year 2006. Which railway has collected the prevailing year, prevailing time, relevant time. That the respondent relied on the railway's letter dated 16/12/2008, by which the railway had rectified the distance for 4 stations from NMGS to Hisar, Bijwasan, and Katar Singhwala and Bhantida. Respectively, by this letter, the railway had corrected the clerical mistake appeared in the railway's letter dated 1/12/2008. However, the distance from Numaligarh to Bhantara remains the same, that is 1854 kilometers. That the railway had never admitted anything about the collection of freight on incorrect distance, and that the applicant respondent also failed to bring on record any material to show the distance for which the railway had collected. Freight was incorrect. As such, the question of alleged refund does not arise at all. The 5, that the railway denied the certificate statement alleged to have been prepared by the CGS and Numaligarh siding by filing evidence on affidavit, and also denied under the provision of Rule 15B of the Railway RCT Procedure Rule 1987, and asked the respondent to prove the said fact. And as such, the respondent was duty bound to bring on record at least some material, but the respondent failed to discharge the burden, and hence the claim is not maintainable in law. That the railway's letter dated 1/12/2008, the distance of station was informed to the respondent, which was prevailing at the time of said period. By the letter, railway had never rectified, corrected any distance quoted by letter dated 5/9/2006. This is my submission before during the hearing of this case, my lord. Now the distance which was reflected in the railway letter dated 5/6/9 were correct and prevailing at the period of time, except the distance on to Rachi, which was subsequently corrected, and applicant had also not raised any objection to such correction. Similarly, by railway's letter dated 16/12/2008, the clerical mistake appeared in the railway's letter dated 1/12/2008 were rectified, and nothing has been mentioned in the respect of the distance reflected in the railway's letter 5/9/2006. Hence, the observation of the tribunal that the railway had rectified the distance reflected in the letter dated 5/9/2006 is not correct. Hence, the claim for the refund was baseless. That while this is the delay for that there would be 8 number, there would not be any scope for the learned tribunal to exercise power under Contempt of Courts Act, despite tribunal had directed applicant to pay a sum of rupees 25,000 as additional cost, which is contrary to the jurisdiction rules of the claim tribunal, and having not considered the said state provisions of law and caused the miscarriage of justice, and has the impugned judgment is without jurisdiction and liable to be set aside and quashed. This was my submission, my lord. My lord, in the finding of this honorable court, it was altered. The finding. Yes, yes. In the 16 contention of the railways in MFA number 12 of 2009 are page 57, my written argument, my lord, that the railway never issued any certificate of or statement, yet the learned tribunal wrongly treated the same as a genuine, and that correction of the distance made in 2008 could not retrospectively alter the chargeable distance applicable during the year 2006-2008, and the said claim was time barred.
What was
And
what was the reasoning of the
my lord,
court in dismissing the appeal?
The honorable court had dismissed the railway appeal and also the dismissed their our
Cross
appeal.
appeal.
So the enhancement of interest was dismissed, Lordship.
What was the reasoning?
Reasoning is that the distance which they have charged, Lordship, is according to the letter that they have issued time to time, and based on that letter, Lordship, we have calculated our amount, and accordingly that amount was admitted by them, and they have issued the certificate, and that certificate was confirmed from the RTI as well. And based on this letter which we have received from the RTI as well as the letter certificate issued by the CGS, based on these two letters, Lordship, decree has been awarded to us. And same order has been upheld by this honorable court, Lordship. This is the order, Lordship.
This is their submission. I already made our submissions, my lord. But in the finding of this judgment, my lord, that in para 16, the contents of the railway and MFA number, what are these? Already we stated. Depending on undergate while returning their stand before the tribunal, file cross appeal so and so. Then a finding was made by the Honorable Court that in this case, in my contention before the
Where are you reading?
in the appeal, my grounds and the contention before the hearing of this case also, which is I have already stated, I already read in the judgment also. Now, on finding the Honorable Court on the issue regarding the entitlement to refund, the record clearly established railway letter dated 1/12/2008 and 16/12/2008 that the distance between Numaligarh refinery siding to Bantara was corrected from 1953 km to 1854 km. The excess freight 99 km is not seriously disputed by railway. In fact, during the proceeding on 1/5/2005, Learned Senior Special Counsel fairly submitted that there is an admission of the incorrect distance calculation. What is the incorrect distance? I have collected on the prevailing distance on the prevailing time. And now this admission of incorrect distance, whatever they submitted, this is incorrect. That is admitted. And that railway had admitted the liability. Yeah, whatever the RCT is allowed, granted to the compensation, I have to accept it. They have granted. But now it will be they are entitled or not, railway whether entitled to refund or not. It is up to the Honorable Court. And I have to admit it that RCT has granted liability so and so. I have to admit it. Such a further submission that the appeal challenged the entire judgment, therefore same was sought to obtain necessary extent from the railway authorities. The contention certificate, to whatever the instruction I have to take, as per ground of appeal and contention during the hearing of this case, my lord, I already stated, along with the documentary evidence, the further instruction taken does not arise, my lord, which is on the basis of the records. Yeah, it does not mean I admitted the railway collected on a wrong distance. I have not admitted. I admitted whatever they submitted, or this is incorrect distance. I have to agree. This is their contention, their submission. They have got this railway collected from for 1953 km, which was to be 1854 km. Now, it is the award granted by the RCT, 55,88,240. I cannot deny it.
This distance is same in all the cases.
No, yes. This thing is same on these cases, my lord.
All the cases.
And
difference is-
in my documentary evidence, in my written argument, my lord, I have already annexed whether distance is changed or not. Whatever they claim that it is incorrect distance, and it is as per railway, it is not incorrect. It's correct. They have collected the freight on a correct distance at the prevailing time, which is evident.
Read para 20.
My lord, in para, my written argument, my lord, in para, sub-para D, para 3, yes, my lord. Under issue number 2 and 3 concern, page 66, para 2, sub-para D, in page number 7 of my written argument. My written argument. Para D, page 7. The respondent applicant had relied on a letter dated 11/8/2006.
Page 7 of the
Written argument, my lord.
an argument of the appeal or cross objection.
No, mean MIP 15 of 2019. In my appeal, my lord, not a cross appeal. MIP 180, it is a cross appeal. And MIP 15 of 2019 is my appeal, filed by railway, my lord.
Yes.
In this written argument of MIP 15 of 2019, page number 7, my lord. This is para 2D.
Yes.
These respondent applicant had relied on letter dated 11/8/2006 issued by the respondent applicant to the Chief Commercial Manager FM NF Railway as respondent applicant's document number 1 and closed with the claim application. By this above letter, the respondent applicant had made a categorical admission to the fact that due to the various reasons like commissioning new lines, removal of inflected distance due to bridge and barrier, etc., there has been a change of distance between junction to junction, and in view of the said circumstances, a request was made to provide the current and updated distance charge from the Chief Commercial Manager Railway for the consignment which are likely to be booked. However, the learned RCT, having failed to consider the condition of the said letter and admission on the part of the respondent applicant, has caused grave error of law. Judgment is liable to be set aside. This copy of letter dated 11/8/2006, I have annexed in my document, Annexer 1, my lord. Annexer 1 at page
What
19.
railway has failed to, RCT has failed to consider?
RCT denied. In my issue under issue number 3, issue number 2.
No, here you have.
In para number 10, yeah, already RCT or written everything, my lord, about the letter dated 11/8/2008 and whatever the distance between the.
In page 8 of your argument.
My lord,
Page 8 of your written argument.
page 8.
Page 8.
No, page 8 of written argument, my lord.
Number D.
D, yes, my lord.
In page 8.
It is as per letter dated 11/8/2006.
Listen to my
My lord.
query. Listen to my query. You have mentioned that the Railway Claims Tribunal have failed to consider the contents of the said letter.
Yes.
What it has failed?
Yes, my lord. Lordship can see in Annexer 1, page 19, my lord, letter dated 11/8/2006.
Yes.
It has been observed that there has been changes in the distance between the junction station of various zonal railway and road at destination station to which consignments are booked. X in Numaligarh Junction due to various reasons like commissioning of new lines, removal of initiated distance due to bridge, barriers, etc. For example, the average chargeable distance between the main Malda town junction and Asansol junction is 248.909 kilometer, say 249 kilometer as per distance table number 5 of Eastern Railway effective from 1/1/2005, whereas this distance has been shown 261 kilometer in the breakdown of this breakup of distance to Balasore, etc., communicated by your office via letter dated so-and-so 14/8/2001. Copy of this letter is enclosed for ready reference Annexer 1. This is leading to an overcharge equivalent to 12 kilometer against the all consignment booked by us via Malda Asansol. In view of the above, you would request your urgent necessary action to circulate the current chargeable distance to various destinations based on latest updated distance tables of various zonal railway, which consignments are booked, likely to be booked ex Numaligarh to facilitate and expedite necessary action at your end. We are enclosing list of such destination as Annexer 2. We should also request you to provide the breakup of calculated distance and to copy of distance table for our reference on record. Here, this is from the Numaligarh. Numaligarh requested the CCM
Numaligarh requested the Railways Authority that
to find out the correct
that
distance.
there is a discrepancy in the distance
Yes.
shown in your rate charge.
Yes, my lord.
Therefore,
Yes,
give us correct rate charges.
yes, my lord. So this is the then letter dated 5/9/2000.
Then you admitted that discrepancy. In your
This is the railway, Numiligar asked the railway to give the distance chart.
What was the response?
My lord,
What was your response?
yes, my lord, they have already given in letter dated 5/9/2006, which is annexed here in page number 21. What are the distance? The railway has already given the distance chart. Page 21. From Numaligarh Junction to Banthara, Kathiyar via Kathiyar, CI, BSS 1953. 1953 kilometers. The railway collected a freight over the distance 1953 kilometers. Now they are saying railway collected overcharges. This is the distance chart of the railway. Now, my lord, again, letter dated 3/31.
On what basis they are saying
My lord,
that they have been overcharged? Yes, Ms. Sharma.
As per their letter dated 1/12/2008 and 16/12/2008.
112.
1/12/2008 and 16/12/2008. They have corrected the distance, Lordship.
But her submission is that these letters are issued in the year 2008.
Lordship, first of all, we have requested them to furnish the latest chargeable, the actual current chargeable distance based on the latest distance table, Lordship. Thereafter, they have issued one letter dated 5/9/2006, where they have.
Nine?
Lordship.
Letter dated
5/9/2006. In response to our letter dated 11/8/2006, they have furnished us the distance of various stations, Lordship. Here, Lordship, in item number, serial number 3, the distance from NMGS to Banthara is 1953 kilometers.
Yes.
Again, Lordship, in serial number 7, which is also the subject distance, Lordship, here Qatar Singh Wala, the distance is mentioned as 2507 kilometers.
Yes.
Thereafter, serial number 6, Bathinda, Lordship, distance is stated as 2512 kilometers. And in item number 8, Hisar, distance is stated as 2395 kilometers. Again, Lordship, at serial number 27, distance of Ranchi is 1378 kilometers.
Yes.
Now, Lordship, after issuing this letter, Lordship, they have issued another letter 31/7/2008. After 2 years, they have stated that the distance between NMGs to Ranchi was shown as 1378 kilometers in the letter dated 5/9/2006, which was supposed to be 1443 kilometers. So they have corrected the distance for Ranchi station.
Okay.
And accordingly, Lordship, they have raised an area of rupees 98,35,378.
After 2 years.
After 2 years, they have raised this amount, Lordship, to us. And for the period 2006 to 2008, Lordship, it is mentioned 2006, 18/9/2006 to 23/7/2008. So because of these changes, Lordship, we again issued one letter that is 28/11/2008. We wanted to know that if you have corrected the distance for Ranchi station, what are the changes in the other 5 stations? That is Banthara, Hisar, Bijwasan, Qatar Singh Wala and Bathinda. Then, Lordship, they have issued 1/12/2008 letter, and they have stated that in response to your letter cited above, that is our letter dated 28/11/2008, it is to inform you that the chargeable distance for goods traffic from NMGS to the different destination stations are as under. Now they have corrected the distance.
This is lesser distance.
Lordship?
This is lesser distance.
Yes.
Then what was?
Compared to the distance
Yeah,
taken
yeah.
in the letter dated
I mean-
5/9/2006, these are lesser distance. Again, they have corrected in another letter that is 16/12/2008 for 4 stations, Lordship. So because of these changes, Lordship, the CGS of the particular station, NMGS, Numaligarh Refinery Siding, that CGS have issued one certificate, and based on this certificate, they have admitted the liability to.
Where is that certificate?
certificate is there in the trial court records, Lordship. Certificate.
This certificate has not been admitted by the railway, or they are already by filing evidence on affidavit before the RCT, admit that the CGS who prepared the certificate, he was no more in the service. The another CGS who was appointed in the Numaligarh siding and forced him to put signature on the Xerox copy of this statement, which was not prepared by the railway. And this was submitted before the RCT, my lord. And in my ground also, in my arguments, I have not admitted this certificate. This is a certificate produced by the respondent, not by the railway. Now they are forcefully submitting that the railway has admitted. How the railway admitted? When the railway has not prepared this certificate, this was prepared by the CGS.
This certificate dated, which certificate?
3/1/2009.
Only this the ground have taken, my lord. In the only before the RCT, the railway file evidence on affidavit, the CGS, the reason CGS in Numaligarh Junction siding, who was holding the post after and forcefully put signature on the Xerox copy of the statement. He filed evidence on affidavit before the RCT. At that time, computer system was not available, and I was forced to put signature here without any.
Whether the witness was cross-examined.
Yes, Your Honor. And that time, Lordship, the deponent, the witness, Lordship, he has withdrawn the word compelled. He has stated in his evidence on affidavit that he was compelled to put his signature because he saw the signature of the previous CGS of that particular station. So because of that, Lordship, he put his own signature out of compulsion. Later on, Lordship, he just withdrawn his word, that compel word, Lordship. And one more aspect, Lordship, at that point of time, Lordship, computerized system was there, Lordship, because to prove our aspect, Lordship, we have submitted 4 samples of railway receipt, which was the computerized railway receipt of that period, 2008, Lordship. And these aspects were already dealt by this honorable court in the judgment dated judgment in passed in MFA 12 or 2019, Lordship.
Yes.
So far as the certificate issued by the CGS, Lordship, these certificates were later, Lordship, affirmed by the RTI, Lordship. We have obtained information through RTI, and in the RTI letter dated 14/6/2017, Lordship, they have confirmed that these documents were available in their office. Because these documents were in huge volume, Lordship, they cannot furnish the documents, so they just requested us to visit their office to check them, to check it very physically, Lordship, to verify the documents physically. And the documents which we have annexed, Lordship, same documents they have attested, Lordship.
You submit your gist of written argument.
I have prepared it, Lordship.
Heard Miss U. Chakrabarti, learned senior standing counsel, appearing for. This is common order in item number 11 and 17. 11, 17. Also Miss M. Sharma, learned counsel for the respondent. Hearing concluded. Both the learned counsels have submitted their written gist of argument. As both these appeals / cross appeal arise out of the common judgment in connection with original application number Roman 3 26/2026 passed by the Railway Claims Tribunal Gauhati on 13/9/2028. Both these appeals are taken up for consideration together. Hearing concluded, judgment reserved.
Obliged to your lordship.
ये दूता 1711 पे लिख के रखे हो और बाकी मैं कोई ऐसा
Lordship, in other three cases,
I'm
the date may be fixed.
in item number 12.
You want to cover, sir?
Item number 12 heard.
Item 12 is related with the item.
Yes, you have given list already.
12 is related with 18.
Yes, item number 12 what लिखिबो
18.
Heard Miss U Chakrabarti, Learned Senior Standing Counsel, Railways, NF Railways, NF Railways, appearing for the appellant, as well as Miss M Sharma, appearing for the respondent. Since this appeal is connected with the MFA 193/2019, both the appeals may be listed together for hearing on the date of short date after 15th of August.
After 15 August, my lord.
After
15 August.
20th of August.
August.
20 August. In 13 लिखिबो
13, 15.
13 same list this matter along with MFA 165/2019 on delegate 25th of August in
October, August.
August.
And minus 14 and 16.
14 of the same parties list this matter along with MFA number 180/2019 on 20 separate date.
No, different date.
September, let it be in September. Separate date be. 3rd of September. 3rd September.
Lordship, 3rd September, I have matters in the family court, Lordship.
10th September.
10 September. 10 September.
10th September. All are taken care of.
Obliged, your lordship.
Obliged.
You may take back this.
Yes.
Next.
Please, your lordship, so the matter can be passed over for the date. And it be
It may be heard, your lordship. Already there has been much delay, your
lordship, the conducting
Even the
council
IA
had
has
to-
not been disposed of.
Lordship, the
It's long back,
conducting
your lordship.
council was had
If
to
one
go
of
somewhere.
you makes submission, I'll be in a position to understand. If both of you jump over each other, one by one you make your submission.
Lordship, the conducting council had to go somewhere urgently. He was here, but he had to go somewhere urgently. He received a phone call and had to
We'll
go.
fix it in,
A short date may be given.
we'll give a short day. Heard Mr. S. Sharma, learned counsel for the appellant, who prays for an adjournment, as the conducting counsel for the appellant has had to leave due to some urgency. Also, Mr. Arkwal, learned counsel for
Claimants.
respondent claimant, no, claimants respondent number 1 to 5. List this one. Also, Mr. U. V.K. Borwa, appearing for respondent number 8.
On Friday, your lordship.
Let this matter. Friday may not be.
This Friday. Or on Monday, your lordship.
On a hearing day, your lordship.
4th of August.
6th, man.
6th of August.
Very well. Good.
Sixth, sir.
It will be difficult. Fifth, it will be there. Fifth on Wednesday.
On a hearing day, Your Lordship. Thursday is the 6th.
Okay, let it be on fifth. Fifth.
Lordship, it will take time.
Yes, it will.
Because
We
we do
don't
not have
have, don't have time.
Date may be given, I do not mind.
We have 15 minutes only.
In fact, yes, my lord, I'm conscious of that paucity of time. Only thing, this is although marked as 2020, it is a 2015 matters. Accident occurred in 2010. Therefore, my lord, your lordship fix a date, a short
Heard
date.
Miss R.D. Majumdar, learned counsel for the appellant, also heard Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta. And Mr. Talukdar, you are appearing for?
In one case, Mr. Talukdar is the respondent, Lordship. And cross objection is by senior Lordship. ঠিক আপনার মাত্র 17-21 নলব
Paucity of time, this Mr. Talukdar appearing for respondent number 125 in MACAPID 104/2020. Mr. S. Datta for cross objector. Let this matter be listed, yes. 3rd of September.
Can it be earlier than that?
Earlier, we are all full.
every day we have to wait.
20th to 20th August. If it is not inconvenient.
20th,
It is not inconvenient for me. It may be inconvenient for you,
I
waiting whole day and matter is not reaching.
Yes.
September, okay. Date এটা হলে একটু সুবিধা 3rd September.
Third September.
Okay, 3rd September.
Obliged.
Highly obliged. What do I do? I will type it.
Then all matters will be adjourned due to paucity of time. Instead of calling one by one, all matters are adjourned due to paucity of time. Registry will give a date as per. Date will be fixed. I'll ask the registry. It will be shown as leftover matter.
The registry will fix the
Item
dates.
24 Lordship.
I'll ask the registrar. I'll call him.
Paucity of time.
Paucity of.
At 27 maybe.
No, no special treatment to any council.
Lordship 24.
Wait, registry will.